on intricacies related to personal guarantor. In the first session, we have CS and IP Harmeet Kaur with us, delivering her thoughts on the topic. I would like to read her brief profile before all the participants. She's an insolvency practitioner registered with IBBI, and a practicing company secretary with over 19 years of experience in corporate secretarial as well as legal practice. Presently, she is a designated partner in RRR Insolvency Service Experts LLP. She has almost 6 years of experience in IBC under various capacities and have handled a voluntary liquidation independently. She has hands-on experience not only in the field of legal drafting, appearances, and insolvency practice, but also in the area of business strategy, financial and corporate restructuring, joint ventures, negotiations, contracts, project development, corporate communication, CSR, and staff welfare. Academically, she is a commerce graduate from SRCC and a law graduate as well. She has impaneled as an independent director with Indian Institute of Corporate Affairs. She is also a certified POS trainer, as in on the ICC of several organizations. We welcome you, ma'am, in this workshop, and it's been a truly privilege for the participants to have your thoughts on the topic. Over to you, ma'am.
Thank you so much. And I think we need to just shorten this profile. It actually helped us waiting for the other participants as well. Thank you, Anjali. Thank you. Thanks to the ICSI IIP. And thanks to the participants who were there on the 4th Saturday, early in the morning. And is my voice all right? Do I need to adjust?
Yes, ma'am. Your voice, audio, and video is perfectly fine.
Okay. So shall I just start sharing the screen?
Yes, ma'am.
Okay. So today's topic, as we are all aware that it is regarding the personal guarantors, and we are also having many confusions regarding this personal guarantors. It has always been a subject of discussion since, I think, 2018 it all started, and laws started settling up, and I have taken the history of this subject as well in during the IBC regime, and how the subject has evolved, how the questions have been raised and settled, and even now we are in the middle of some settlements. We are expecting some solution from the apex court, as well as some changes are expected from the legislature also, because since although the law, it has not yet been implemented fully, only in, the individual insolvency has only been allowed in the case of personal guarantors, but even that has not yet been tested. The practical intricacies will actually start once we will start working on this, and we will see how it goes hereafter. Right now, we are stuck in the middle of it, where the RP has to submit a report, and the NCLTs are not accepting that report, and that is not the middle of the process, it is just the start of the process. So actually the process has not yet kick-started, although it was implemented way back in November 2019 by way of a notification, and it was enforced from 1st December 2019, but still we have not yet seen the entire process going through, and the matter is still with apex court, and almost 60 petitions have been combined, some appeals, some writs, they have all been combined under one case matter, and result is awaited from there. We'll go through that along with the flow of the presentation, but I would like to let you know the concept of personal guarantors, because these are the fundamentals which are generally not covered under the IBC also, and we have seen all of them evolved through the various judgments by Honorable Supreme Court, and we have also understood the laws, all the laws connected to this subject. Let me just, Anjali, I'll just take your leave and I'll switch off my camera, because I don't know the quality of the internet at home. So excuse me for this. And let us just start with the concept. If anyone has any addition to what we are discussing, I would welcome the discussions, but please refrain to touch the subject which is not in the context today, and any discussions related to the content and the context are welcome. A personal guarantor is an individual who provides a guarantee to secure the obligations of a borrower, generally a corporate entity, towards a lender. So anyone has any questions, any doubts on why the guarantee is taken at all? Anyone who is having a soft corner for the personal guarantors, I am with you. And I also initially thought that, initially means almost 10 to 12 years ago, while I was a part of a CD, not a CD, a debtor. And I used to think why poor personal guarantors are, you know, entangled in the entire process of loan which has been taken by the borrower. The principal borrower should be, you know, responsible for paying off, should be liable for all the losses, etc., should be liable for paying for repayments. But why the personal guarantors? So anyone who is also thinking on the same lines, or anyone who is having a different view, and why personal guarantee is such an important concept, and why all the lenders, virtually all of them, even if they don't actually need it, they are needing it. They don't actually require it, but they are insisting on having a personal guarantee for any kind of loan. Anyone?
It's a type of security. It's a type of comfort.
Yeah.
That creditors get.
Yes. Over the years, have you seen any change in the behavior of the lenders regarding this concept?
I don't think so.
Yeah. Since inception, it has been there, and it should be there in a way to promote the lending, the lenders markets, and give a comfort to them, because they are providing you the base to run your business. They are giving you, even the working capital should be, secured in one or the other way. So long-term loans, term lending is always better from the lender's perspective, from the economy perspective, from the business, and the comfort to the lenders will virtually lead to the flow of the funds in the market, and it will be ultimately beneficial for the entire economy. So we understand the concept and why is it so essential. The definition of guarantor is given under the Indian Contracts Act. It says that it reflects upon the guiding principles behind a contract of guarantee, which is a tripartite contract between a surety, the principal debtor, and the creditor, wherein the liability of the guarantor is coextensive with that of the principal debtor. This is a well-settled law under IBC also now. Thus, the guarantor's liability to make good the payments on behalf of the principal debtor arises as soon as the principal debtor fails to fulfill its obligations under the contract. We are all aware about the subject now. This settled principle of law, we are aware about it now. The guarantee furnished by a person to the CD can be invoked even prior to resorting to the CD. This is also a settled law now. We'll see how it has become settled and evolved during the last 5 years. Basis the aforementioned principles of the ICA, a personal guarantor under the code is defined under section 5 subsection 22 as an individual who is the surety in a contract of guarantee to the CD. Rule 3, sub-rule 1, subclause E of Insolvency and Bankruptcy Application to AA for Insolvency Resolution Professional for Personal Guarantors to CD Rules 2019, however, defines a guarantor as a debtor who is a personal guarantor to a CD and in respect of whom guarantee has been invoked by the creditor and remains unpaid in full or part. So these are the various definitions provided under all the affecting laws to us.
Madam, in the present, I'm sorry for interrupting. In the present scenario, whether bank is still insisting for personal guarantee in case of loan if corporate debtor is providing sufficient security in terms of land and building and other securities, then what is the present scenario?
Yes, yes, they are. As I told you that even if it is not needed, from the perspective of the collaterals they are getting, the corporate guarantees they are getting, they still want some other person who is having an exposure in the same business to which they are getting exposed, the business or the project for which the loan is being taken, on the basis of the projections that are being presented by those promoters themselves. If they believe in their project, then the bankers are insisting that, yes, how would we believe that you are there on the same boat? So they are insisting in all the cases, they are now insisting the personal
So
guarantee.
you mean to say no personal guarantee, no loan?
Generally, yes. In the businesses, yes.
Okay.
Yeah.
Thank you.
Prior to the notification dated 15th November 2019, how was the scenario? It was still getting evolved. The concept was still getting laid down rightly. For example, in the case of State Bank of India versus V. Ramakrishnan and another, that was decided in August 2018, the issue that came for consideration in this case was if Section 14 of IBC, which provides for a moratorium for the limited period, would apply to personal guarantor of a CD as well. In this judgment, the Honorable Supreme Court clarified that the moratorium is applicable only on the CD and not on the personal guarantors. So that was a clarity given much earlier than this notification. Another matter which was decided prior to this notification, wherein two questions of law arose for consideration before the NCLAT, whether the CIRP can be initiated against a corporate guarantor if the principal borrower is not a CD or a corporate person, and whether the CRP can be initiated against two corporate guarantors simultaneously for the same set of debt and default. So here in Piramal matter, basically the question was not related to the personal guarantors, it was related to the corporate guarantor, but still it paved some way and caused a confusion in the entire spectrum. Thereafter, when the notification rules and regulations were given, thereafter some clarity was also shed on these subjects. While answering the first question, the Honorable NCLAT held that before initiating the CRP against the corporate guarantors, it is not necessary to initiate an insolvency resolution against the principal borrower. Secondly, on the second question, it held that if CRP has been initiated against one of the corporate debtors, then after such initiation, CRP cannot be triggered for the same debt against the other corporate debtor. So here, on the second point, the Honorable Supreme Court gave another aspect to this, and it was later on decided that CRP can be initiated. Initiated means not admission. Initiated means an application for admission can be filed against the CD, and the CD here would mean not only the principal borrower, but also the guarantor. So both the applications can run simultaneously. That was decided after this Piramal judgment, and we'll go through that as well. In SBI versus Athena Energy, what happened here was NCLAT gave a contrary view in its judgment dated November 2020, where it was held that simultaneous initiation of CRP against a principal borrower and its corporate guarantor is permissible. The NCLAT noted that the issue under the Piramal judgment was whether CRP could be initiated against two corporate guarantors simultaneously for the same set of debt and default, and not if the application can be filed against the principal borrower as well as the corporate guarantor. Also, NCLAT observed that Piramal judgment did not notice Section 60, subsection 2 and subsection 3 of the IBC. So here, another important principle of law was laid down, that simultaneous initiation of CRP against a principal borrower as well as its corporate guarantor is permissible. Then came the important notification, 15 November 2019, an amendment to IBC. And these were all the sections which were affected, and some of them were implemented. In exercise of the powers conferred by subsection 3 of section 1 of Insolvency and Bankruptcy Code, the central government hereby appoints the first day of December 2019 as the date in which the following provisions of the said code, only insofar as they relate to personal guarantors to CD, shall come into force. Now, what does it mean? Insolvency proceedings against the personal guarantors. Earlier, the IBC did not recognize the personal guarantors as a separate class of individuals against whom insolvency proceedings could be initiated. It was only after the enactment of IBC that personal guarantors were recognized as a separate class of individuals. The said amendment also empowered NCLT to act as adjudicating authority for insolvency proceedings against personal guarantors. To further the objective of the above amendment, Part 3 of IBC was made applicable to personal guarantors of the principal borrowers by way of a notification that we have just seen. As a result, creditors could initiate insolvency proceedings against the personal guarantors before an NCLT under the amended section 60 subsection 1 and 2 read with section 95 of IBC. With this amendment, a creditor now has the option to initiate insolvency proceedings against the personal guarantor. Under Chapter 3, the process closely aligns with the CRP process under the IBC with some major differences, which I have enumerated later. What is the implication of this for the personal guarantor? Their inclusion has significant implication for themselves who have given the guarantee. They are now exposed to the risk of insolvency proceedings leading to the potential loss of their personal assets as well. Personal guarantors must be cautious when providing guarantees and fully comprehend the financial risks involved with that particular borrower. What is the effect of the notification? That various petitions, after this notification came into effect, various petitions challenging the notification were filed by the promoters, directors, etc. in various high courts of the country, raising the questions on the bias and the constitutionality of the said notification. IBBI moved an application before the Honorable Supreme Court of India and asked to take it at utmost importance. The Honorable Supreme Court, while exercising its powers under Article 139A to transfer the cases and settle the common question of law, under Article 32 concerning the interpretation of the provisions of the code, presided on this matter. So what are the Articles 139A and 32? I will quickly go through them. Transfer of certain cases. Where cases involving the same or substantially the same question of law are pending before the Supreme Court and one of or more of the high courts or between two or more high courts, and the Supreme Court is satisfied on its own motion or an application made by the Attorney General of India or by a party to any such case, that such questions are substantial questions of general importance, the Supreme Court may withdraw the cases or cases pending before the High Court or the High Courts and dispose of all of the cases itself, provided that the Supreme Court may, after determining the said questions of law, return any case so withdrawn together with a copy of its judgment on the questions to the High Court from which the case has been so transferred. The Supreme Court may, if it deems so expedient to do so, for the ends of justice, transfer any case, appeal, or other proceedings pending before any High Court to any other High Court as well. What is Article 32? Remedies for enforcement of rights conferred. The right to move the Supreme Court by appropriate proceedings for the enforcement of the rights conferred by this part is guaranteed. The Supreme Court shall have power to issue directions or orders or writs, as they are popularly known, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, whichever may be appropriate, for the enforcement of any of the rights conferred by this part. I'm sure all of us are aware about these now. Without prejudice to the powers conferred on the Supreme Court by Clause 1 and 2, Parliament may, by law, empower any other court to exercise within the local limits. So this is the Article 32, and the Supreme Court exercised its powers under Article 139A and 32 to decide about the questions raised after the notification of personal guarantors. This is a landmark judgment, Lalit Kumar Jain versus Union Bank of India, wherein a lot of clarifications were given by the apex court. First of all, being the sanction of a resolution plan and its finality under Section 31 of IPC does not per se discharge the guarantor's liability. It is still being discussed and it is still being a matter of consideration under various applications pending before NCLT and NCLAT, wherein it is being asked then after the plan is approved, the creditor has extinguished its liability and they don't have any further right to go behind the personal guarantor. But it was well settled in the Lalit Kumar case itself that in a case of an unequivocal guarantee, the liability of a guarantor continues as there is no discharge under Section 134(9) of the Contract Act. It was observed that the principal debtor is discharged by an involuntary process of operation of law and not by an act or omission of the creditor, and thus the creditor can proceed against the guarantor. Here, one very interesting concept I just came to know while preparing for this presentation itself, that in a resolution plan, there is an agreement between the creditor and the CD. But that agreement is not between the creditor and the guarantor. Guarantor is still there. Their agreement is still pending to be settled, and the creditor still has rights to go to enforce the guarantees given by those corporate guarantors or the personal guarantors, even beyond settlement under the plan with the CD. With the CD and the new acquirer, essentially there is the agreement between the creditor and the resolution applicant, and the corporate debtor, even the corporate guarantor and the personal guarantor, they also fall under the category of corporate debtor for the remaining portion of the loan. So creditors' rights are still alive. Therefore, the discharge of liability of the CD due to an operation of law in liquidation proceedings also does not ipso facto absolve the personal guarantor from its liability. It also held that a discharge of liability could not be sought by the guarantor upon approval of a resolution plan which could contain terms allowing continuation of debt of the guarantors. So it was decided in SBI versus V. Ramakrishnan. Section 179 of the code provides that subject to Section 60 of the code, the adjudicating authority for bankruptcy matters relating to individuals would be debt recovery tribunal. So the Honorable Supreme Court observed that the legislative intent was to treat the personal guarantors differently from the other class of individuals, as evident from Section 179, which specifically gives a carve-out for Section 70. The above provision is subject to Section 60, which provides that adjudicating authority for insolvency matters relating to corporate persons would be NCLT and not the DRT. It further held that Section 31, subsection 1 of the code makes it clear that the guarantor cannot escape payment, since the resolution plan which has been approved by the NCLT may also include the provisions of payment to be made by such guarantor. Therefore, finality to the insolvency proceedings per se does not operate as a discharge of guarantor's liability under the contract of guarantee.
If it is written in the resolution plan that personal guarantor shall be absolved irrespective of the haircuts given in the resolution plan.
Yes.
Is it valid resolution plan, and whether...
Yes. And
Okay.
we will cover that also, because that has also been held by Honorable Supreme Court in one of the matters. That is also part of my presentation here, because the questions were raised on the validity of treating such liabilities which were absolving the personal guarantor or the corporate guarantor. So there was a family trust wherein personal guarantors were set free against a particular resolution amount within the resolution plan itself. So that
can you give me the case number, or
we will see that during this presentation itself. There was a family trust matter. I'll just see. So those writ petitions were dismissed, and that was a major relief in terms of the understanding of this notification. So it laid down important principles of law. One is coextensive liability. Since the liability of the personal guarantor arises from an independent contract, the nature and extent of the liability would depend on the terms under the contract. Therefore, the creditors have the option to simultaneously proceed against the CD and its personal guarantor, or they can choose to proceed in any order. Supreme Court also clarified that the sanction of resolution plan and its finality does not discharge the guarantor's liability. It relied on the Maharashtra State Electricity Board versus official liquidator matter. It held that within the meaning of Section 128 of the Contract Act, in a case of an unequivocal guarantee, the liability of the guarantor continues as there is no discharge under Section 134 of the Contract Act. It observed that the principal debtor is discharged by an involuntary process of operation of law and not by the act or omission by the creditor.
What if, madam, if terms and conditions get varies in the case of personal guarantee, in that case, without the consent of the guarantor, or with then what will be the situation if without the consent of the guarantor?
Varying at which platform the variation is taking place. It cannot take place without his concurrence because he is a party to that guarantee agreement.
The person who has given the guarantee is a part of the contract, but the conditions of the guarantee gets varies without his consent.
No, conditions cannot be varied without his consent.
Or if it get varies, then
it is not valid. He can always raise that subject before any adjudicating authority or any appropriate authority.
Okay, thank you.
Madam, this is Dipti Tite. Yes. Actually, when the sir is saying that the terms conditions get varied, so in that case, won't it amount to modification of a charge and then the new agreement has to be registered?
See, modification of charge is not the terms and conditions getting varied for the same amount of debt. If the same, the guarantor is continuing, only the beneficiary is changing. So that is the consequence of the resolution plan. And it is not about a change in the terms and conditions. The new contracts will be entered into. The guarantor is not absolved of his liability at any point of time. It's only the ultimate beneficiary, the lender, or whosoever is providing the money in this case. They can take place. The creditor might change or creditor may be the same, but the contract may get changed. The terms cannot be varied without his consent.
That is what I am saying, that when the terms get changed, he needs to enter a new guarantee.
Yes. New
so without his consent, the terms will not be changed.
Yes.
Otherwise, he will have to give a new guarantor if he does not agree to those terms, new terms.
Yes.
Yes. Thank you.
So in the Lalit Kumar matter, the principle of double dip was also catered. And it was, while it was raised that the same amount of default, same amount of debt, whether two applications can continue and all those questions were raised. So it was clarified the creditors can proceed against either or both principal borrower and guarantor. However, if both are insolvent, that means both are not able to pay the debt or insolvency, or one of them has completed the insolvency process, etc., then the creditor can proceed against each for the full amount but cannot recover more than the full amount. Therefore, the Supreme Court recognized the double dip principle and allowed the recovery of only the stipulated debt amount, irrespective of who the creditor decides to proceed against and in which order. So the much awaited clarity was given by this order. And the Supreme Court in this case also held that the exception to moratorium envisaged under Section 14 extends to only the corporate guarantors and not the personal guarantors, thereby allowing a possibility of moratorium protection to personal guarantors, unlike corporate guarantors. There is still an impending need for IBC to address such gaps in the legislation, especially in case of differential treatment of personal guarantors and corporate guarantors, right? Because personal guarantors are treated under the individual insolvency, which we'll just go through today. The ramifications of this notification, the impact. In each of the large cases, multiple creditors had to take severe haircuts, and for some, no payment was proposed as the payment offered by the resolution applicant was enough to only repay secured financial creditors. While some creditors, including public sector banks, faced huge financial losses, the promoter entities or individuals continued being financially sound. Supreme Court explained that the sanction of a resolution plan and conclusion of a CRP of principal borrower does not discharge a guarantor from its liability. Accordingly, creditors can initiate insolvency resolution process against the personal guarantors after the CIRP of the principal borrower has concluded. Thus, if creditors believe that they have access to the excessive haircuts in a CIRP of the principal borrower, they are permitted to proceed against the personal guarantors as well.
Can bank can proceed whether bank can proceed against the personal guarantor without initiating CIRP against CD?
Yes.
Straightforward.
Yes.
Okay.
So this judgment also clarifies that such creditors can now initiate insolvency proceedings against the guarantors even before commencing a CIRP. That answers your question. Against the principal borrower. Therefore, it appears that creditors are now in a safer space with respect to realizing their dues. Do you also feel so that they are now in a much safer space and they have got a larger pool of assets to recover their dues?
Yes, definitely, madam.
Do you think so? Okay.
Yes.
We'll come to this also later because I have a different view in this. Additionally, in an insolvency resolution process against the personal guarantors, an interim moratorium is imposed from the date of filing of an application. During such interim moratorium, any legal action or proceeding in respect of any debt owed by the personal guarantor is stayed. This is very important difference from the CIRP. In the CIRP, only from the admission date of the CIRP, of the application, admission of application date would be the commencement of CIRP as well as the commencement of moratorium under Section 14. But here, the interim moratorium is imposed right from the initiation of the IRP process. That is the date of filing of the application. So the other creditors of the personal guarantor cannot initiate any legal action, including enforcement of their security interests in respect of the personal guarantor's assets. In an insolvency resolution process against the personal guarantors, a creditor can nominate a resolution professional.
What is the rationale behind that?
Sorry, yeah.
What is the rationale behind that?
See, personal guarantors definitely need protection. And if all the secured creditors start taking action at the same time in different manners, one is going for insolvency resolution process, another is going to, sell the assets of that guarantor. So on the same pool of assets, once the application is filed for insolvency resolution, then all of them will have to either join that process or relinquish their rights. So that also we will consider later. Here, secured creditors are given two options, whether to join this process and be a part of the committee of creditors, keep voting on the repayment plan, etc., or to be away from this process. So they have got two ways, but they cannot take any action. But very interestingly, the promoter is not stopped from selling his assets during this interim moratorium period. That is also very interesting to understand. We'll also see that when we'll go through the sections of IBC hereafter. So the entire process I have covered here. In an insolvency resolution process against the personal guarantor, a creditor can nominate an RP who prepares a report on whether the application should be admitted by the NCLT. So we are here. We have only stopped here practically in today's scenario. Even the reports are not being accepted by the NCLTs, and thereafter the process starts. The process of insolvency resolution process of the personal guarantors has not yet taken place actually. Till now, because of the deemed stay by the Supreme Court in one of the matters, and the other NCLTs are just following that stay. The NCLT thereafter, the NCLT passes an order for acceptance or rejection of the creditor's application. This process can possibly be completed within a period of 30 days. An order accepting the initiation implies that a moratorium is imposed in terms of Section 101. That is the proper moratorium. And
it is period of 14 days, no, ma'am?
No, this is 14 plus 14 next.
So initial period is 14 days.
Yes, initial is 14 and thereafter after submission of report by the RP, NCLT will also...
No, for the submission of the RP report, only 10 days is given. And after the submission of report, the NCLT should pass an order within 14 days.
So virtually 24 days.
Yeah.
Right. I correct this.
But in the practical scenario,
PR
they
approach.
have taken 2 years time, and still they have not issued a pass order.
Yeah, that is because of the stay. Okay. So the other moratorium which I was talking about, which will be applicable after the application is accepted and the case is admitted, that shall bar the personal guarantor from transferring or selling or encumbering or disposing of any of his assets, legal rights or beneficial interests, etc., which appears to be a severe consequence, as the same can cause significant hardship to that individual. This might prompt promoters standing as personal guarantors to contemplate repaying the creditors of CD also, as well as refraining from initiating any frivolous litigation which can delay the CRP of the CD. On the other hand,
that means, madam, from the date of initiation or the filing of the application, till the order is passed under section 101, there is a moratorium that nobody can take any action against the personal guarantor. But the personal guarantor can sell his own property.
No, they cannot. From the date, the moratorium under section 101, that is the moratorium after the admission of application for commencement of insolvency resolution process against a personal guarantor. That during that moratorium, promoter cannot sell. But during the period, the application is still pending and it has not yet got accepted or admitted by the NCLT. That time the person can sell.
That I'm telling, when the application is filed with NCLT, then moratorium period starts.
That is the interim moratorium.
That interim moratorium period. That interim moratorium period lasts till order is passed under section 101. During this interim moratorium period, nobody can take any action against the personal guarantor, but the personal guarantor can dispose.
Yes.
That is the point that I'm. That is the point, because here last 2 years back or 1 year back, these applications are filed, and creditors are unable to take any action against the personal guarantor, but the personal guarantors are in their liberty to dispose of the assets. That is the point I'm.
Yes, absolutely. So for the creditors, it would be commercially prudent to obtain a personal guarantee by the promoters at the time of executing any lending agreement. Creditors can invoke such personal guarantee in the event of default by the CD, even without going against the CD itself. So under the IBC, the jurisdiction is NCLT. It would lie with the jurisdiction for initiating insolvency and bankruptcy proceedings against a personal guarantor to a CD would lie with NCLT in cases where CIRP has already been initiated or is pending against the CD of the personal guarantor. In this regard, NCLT shall be vested with all the powers of DRT as contemplated under Part 3 of this code. In all other cases, the jurisdiction in respect of initiating insolvency and bankruptcy proceedings against a personal guarantor would lie with Debt Recovery Tribunal. So let's go through the law. The Part 3 of IBC, Chapter 1, Section 78, insolvency and bankruptcy of individuals can be initiated where the amount of default is more than 1,000 rupees, provided that the central government may by notification specify minimum amount of default of higher value, which shall not be more than 1 lakh rupees. So Section 80 to 93 are not yet notified, and individuals and proprietorship firms and partnership firms are not yet covered under the ambit of IBC. We are only talking about the personal guarantors, one category of individuals. The MCA enacted rules to govern the proceedings under Part 3. They are called...
Madam, one point, please.
Yes.
Suppose financial creditors find difficulty that due to threshold limit, 1 crore, they cannot go against the corporate debtor. And let us say the amount outstanding, the default amount is 90 lakhs. In that case, they cannot go to go under Section 7. Can they, in that case, can they initiate action under section 94, 95?
Yeah. Yes. Yes,
Okay.
they can.
Okay.
So the rules are the insolvency and bankruptcy application to AA for insolvency resolution process for personal guarantors to corporate debtors rules that are the insolvency rules, and similarly the bankruptcy rules are also notified. So they are mostly similar to the CIRP and liquidation processes. Even the entire process is also quite similar with some major differences which we will come to know today. And the regulations are also framed by the IBBI, that are the insolvency regulations and bankruptcy regulations. So major differences between CRP and individual insolvency process is, under CRP, we know the creditors as financial and operational, but in individual insolvency, there is only one classification, that is secured and unsecured. So no, all financial and operational creditors are treated at par as far as they are, and only they are categorized as secured or unsecured. The interim moratorium is not available under CRP, and that is a huge relief under individual insolvency. Role of the RP starts from the admission of application. While in the individual insolvency, it starts much prior to the admission. The RP has to scrutinize the application for initiation of the IRP, and if the creditors are taking help of the resolution professional, or if the debtor is taking help of the resolution professional to file the application itself, then it starts, the role starts right from the filing of application itself. Possession of assets remains with the bankruptcy trustee, even in the liquidation process of the individual, that is known as the bankruptcy process. No. In the insolvency resolution process, the assets remain with the personal guarantor and or the individual against whom the insolvency has been initiated. But in the CRP process, assets of the CD have to go, the RP has to take control and custody of the assets of the CD. It is only in the bankruptcy. If the bankruptcy is initiated, then the assets are shifted to the bankruptcy.
One point. When order under section 101 is passed, then the assets of the liquidator remains with assets of the guarantor remains with the guarantor.
Yes.
That the RP does not take control
possession
of the assets.
No.
Okay.
Yeah. The consequence of rejection of the plan is compulsorily liquidation has to be initiated under if CRP fails. And here the creditor whose dues remain unpaid or who had initiated this individual insolvency, they have an option to file an application for bankruptcy. It is up to their choice, although they are entitled, but it is their choice whether to go for selling of the assets of the insolvent individual.
Madam Harmeet ji, I am sorry to say that most of or all IPs are attending this seminar or program, and the main concern is fees. You have not covered the fees aspects, because in CIRP, fees is very much clear in the regulation 30 or 33. But what about in personal guarantee? When and at which time these fees accrues to the RP?
See, the fee accrue, there is no law related to that. It is as per the discussion and agreement between the parties. If a debtor is filing the application and RP is involved right from the day from filing the application, you can discuss with the debtor. If the creditor is filing the application, if the RP is appointed by the adjudicating authority just at the time of scrutinizing the application, then adjudicating authority may decide about the fees. And till such time the fees is not decided by the law, I am no one to comment on
even
the fee
see in CIRP, law is very much clear. Regulation says applicant will bear, but here nothing, neither AA nor this.
So give it
applicant.
some time, sir. Give this also some time to evolve.
Now it's more than 2 years.
So we have not yet conducted, we have not yet seen any individual insolvency going through. It has not yet started.
No, personal guarantor. I am only talking
personal
about
guarantor also, sir. We have not yet started practically. It is still in the ambit of Supreme Court.
No. We have, our clients have already filed this report of solvency or insolvency of this personal guarantor against the order of AA, that whether their application is liable to be admitted or dismissed. So
those
in that
RPs...
case, suppose the RP filed this report within 10 days, who will pay the fees of the report?
Sir, whosoever has admitted him.
What will be fees?
Engaged him.
Yeah, can I come in for a moment?
Yes.
In my case, I have got 2 cases of personal guarantor admitted, and currently it's going on.
Okay. Okay. So 2 cases are already going on. Which banker?
Can you share, sir? Can you share your experience about the fees?
In my case, it was the debtor who had filed an application, so he paid the fees. So there's no question of fees as of now. Yeah.
Sir, I am the RP in 5 cases appointed by PNB, and PNB is paying me.
So is it monthly or fixed fees?
No, sir, that is the how you are.
Sir, I am talking about your case only, and you are dealing with the PNB, so I am just talking about your case, so that we can also.
In my case, I have taken on a consolidated basis.
Okay, consolidated fees. Okay. Thank
Sir,
you.
sir, can you just let me know, because for me 2 orders have been passed by AA appointing me as RP for 2 personal guarantors. So I would just like to know the
Deepti ji, your voice is muted. Can you unmute yourself?
Hello.
Yes.
Sir, because there are 2 orders passed and I have to submit the report.
Okay.
So it will be like very much helpful for me to quote my fees.
That's why everybody has joined today's webinar.
That's true, sir. But
let's
what
just go
should be
through
the
the law.
quantum?
Preeti ji, let's just go through the law, and
Okay.
can be discussed separately.
Sir, I'll get connected with you in individual.
Sure. So,
thank you.
Section 79 gives some of the definitions pertaining to Part 3, and they are, I think, very, very important for us to understand. The excluded assets include unencumbered tools, books, vehicles, and other equipment as are necessary to the debtor or bankrupt for his personal use or for the purpose of his employment, business, or vocation. Unencumbered furniture, household equipment, and provisions as are necessary for satisfying the basic domestic needs of the bankrupt and his immediate family. This definition is actually more important at the time of the handing over of the assets to the bankruptcy trustee, but it has some relevance under insolvency process as well. Any unencumbered personal ornaments of such value as may be prescribed of the debtor or his immediate family which cannot be parted with in accordance with religious usage. Any unencumbered life insurance policy or pension plan taken in the name of the debtor or his immediate family. An unencumbered single dwelling unit owned by the debtor of such value as may be prescribed. So the definition of excluded debt. These debts are not covered under insolvency process, and these shall not be absolved even after the entire process is completed. So these are important from insolvency process perspective also. Liability to pay fine imposed by any court or tribunal. Liability to pay any damages for negligence, nuisance, or breach of a statutory, contractual, or other legal obligation. Liability to pay maintenance to any person under any law for the time being in force. Liability in relation to a student loan. And any other debt as may be prescribed. An associate is the related person. It is essentially the same, having the same meaning as the related party. A person who belongs to the immediate family of the debtor. A person who is a relative of the debtor or the relative of the spouse of the debtor. A person who is in partnership with the debtor. A person who is a spouse or a relative of any person with whom the debtor is in partnership. Is the employer of debtor or employee of the debtor. A person who is a trustee of a trust where beneficiaries of the trust include the debtor. A company where debtor or the debtor along with his associates own more than 50% of the share capital. For the purpose of this section, relative would mean members of HUF or any or one person is related to the other in such manner as been prescribed. Here one catch is there. In the definitions, they call it associate of the debtor, but later on in the insolvency resolution process, the code as well as the regulations, they talk about the associate of the creditors, etc. So we must understand this from the perspective of the related party of the creditor as and when as a case may be. Initiation under section 94, a debtor who commits a default may file an application either personally or through a resolution professional to the adjudicating authority for initiating the insolvency resolution process. An application can be for a debt which is not an excluded debt. It shall not, the debtor shall not be entitled to make an application if he is an undischarged bankrupt. The definition of bankrupt and undischarged bankrupt, etc., are given under section 79, who is undergoing a fresh start process, who is undergoing an insolvency resolution process, or undergoing a bankruptcy process. If an application for insolvency has been admitted during past 12 months preceding the date of submission of this application. Filing of application is in accordance with Rule 7 of Insolvency Rules. The application under 94 subsection 1 shall be submitted in Form A along with an application fee of ₹2,000. The guarantor shall forthwith serve a copy of application to every financial creditor and the CD for whom the guarantor is a personal guarantor. Initiation by the creditor, that is covered under section 95. A creditor may file an application either by himself or jointly with other creditors or through an RP to the AA for initiating insolvency resolution process. Prior to initiating proceedings against a personal guarantor, the creditor is requested to issue a demand notice in accordance with Rule 7 Form B under section 94 4B of the code, calling upon the guarantor to pay up the defaulted unpaid debt within a period of 14 days. The demand notice in case of personal insolvency does not give a chance of disputing the notice. In case of failure to pay upon the demand, the application may be preferred before AA under section 95 subsection 1 in Form C along with fees of ₹2,000. The creditor shall forthwith serve a copy of application to every guarantor and the CD for whom the guarantor is a personal guarantor. In case of a joint application, the creditors may nominate one amongst themselves to act on behalf of all the creditors. Now comes the interim moratorium. The insolvency process for guarantors in terms of section 96 subsection A provides for an interim moratorium in relation to all the debts of the guarantor as soon as the application for insolvency under section 94 or 95 is filed before the AA and ceases to have effect on the date of admission of such application. During the interim moratorium period, any legal action or proceeding pending in respect of any debt shall be deemed to have been stayed. This is about the pending proceedings, and the second one is about the new proceeding. That is, the creditors of the debtor shall not initiate any legal action or proceedings in respect of any debt. Thereafter, the appointment of resolution professional, section 97, where the RP files the application, the AA shall within 7 days seek confirmation from IBBI that there are no disciplinary proceedings based on the above. The RP is appointed and board shall respond within 7 days confirming or rejecting and nominating another RP. So this will take approximately 28 days. While we were discussing about number of days here, a demand notice has to be given for 14 days, right? Thereafter, AA shall seek confirmation from IBBI and IBBI shall respond within 7 more days, confirming or rejecting.
No, madam. Demand notice in Form B is given by the creditor.
Yes.
That is not included here. Once that is given in Form B, the 14 days notice is given. If that remains unresponded or unpaid, after that, maybe after 1 month or immediately after that, that's a simple notice. After that, a creditor files application under section 95. And when the creditor files the application under section 95, at that point of time, it is not, as per law, it is not required to give any notice to the guarantor. Only in case of section 100 rupee, 100 report, that is to be given. But here it is not required. But NCLT, they insist to give such notices to the guarantors. They insist. But as per law, there is no such notices, because at that point of time, there is no provision for hearing from the guarantors.
So we are not talking about hearing.
But you are telling that 14 days, then 7 days. That's why that 14 days, they can give notice in section.
Sir, what I am saying here is the demand notice and the earlier slide where we were discussing about the number of days was roughly the days within which a creditor, any creditor, can go through this process. So initially he will have to give a demand notice, and thereafter he will be filing, right? So there is no confusion with respect to days. I understand.
No, ma'am, that I'm telling, that is, I got confused, because when he gives a notice, 14 days notice, after 3 months also he can file.
Yeah.
Or immediately he can also file. That is
I understand. Yes. So that was only giving a general statement about by when they'll be able to start. So where a debtor or creditor files the application, the AA shall within 7 days write to the IBBI to nominate an RP within 7 days of application, and RP shall be appointed within 10 days of receiving such direction from the IBBI. RP shall be provided a copy of the application. Preliminary assessment of the application by RP, section 99 subsection 1 says that the preliminary assessment on the validity of the insolvency application shall be made by the RP and not by the AA. The RP shall examine the application to ascertain that the application satisfies the requirements of section 94 or 95 as the case may be. The applicant has provided information and given the explanation sought by the RP from him. The RP shall, within 10 days of his appointment, submit a report to the AA recommending for approval or rejection of the application, recording the reasons for the same. Admission or rejection of application, that is section 100. The AA shall, within 14 days from the date of submission of the report by the RP under section 99, pass an order either admitting or rejecting the application referred to in section 94 or 95. Where the AA admits the application, it may, on the request of the RP, issue instructions for the purpose of conducting negotiations between the debtor and creditor and for arriving at a repayment plan. In case of rejection of the application on the ground that the same was made with the intention to defraud the creditors and the RP, the AA shall record that the creditors is entitled to file for a bankruptcy under Chapter 4. So here also creditor is not directed and liquidation is not ordered. It is only that the creditor is entitled to file for a bankruptcy. Now this moratorium shall commence on admission of the application under section 100. Moratorium to remain in effect till the end of 180 days from the date of admission or the date on which AA passes an order on the repayment plan under section 114, whichever is earlier.
Madam, I am sorry to interrupt here. In case of settlement take place between the CD and the lenders, then this personal guarantor will be absolved from this process.
From the process or from his liability?
From liabilities as well as this CRP.
Yeah. So as per the settlement, the terms of the settlement will be laid down in a manner which will cover his liabilities with that particular creditor or with all the creditors, right? So those terms of settlement will be important there, and thereafter he will be absolved of his respective liabilities.
Okay, thank you.
Madam, one question. Madam, one question.
Yes.
That law of limitation is applicable here?
Yes.
Then is it required to determine that limitation period separately for the personal guarantor, or the acknowledgement by the corporate debtor will be sufficient for this purpose?
Acknowledgement by the corporate debtor will be sufficient because the debt actually pertains to the corporate debtor.
Okay, then my point is that suppose in 2017 or 18, company when 2014 that debt become default, and 2017 or 18 the company went into CIRP.
Yeah, thanda pani dena.
Then suppose 2019.
Please come again. I could not hear the complete question.
Yes, ma'am, a company, I'm just giving an example. Yeah. A debt become default in the year 2014. Then the company went into CRP in the year 2017 and 2019 company went into liquidation. And 2019 liquidator suppose admitted in the CRP RP admitted some amount, and 2019 liquidator admitted some amount. Then after liquidation, liquidator paid some amount. And 2023, the financial creditor files application under section 95. Now the point is that whether this application within the limitation period or not. The question, and now the point is that as it was admitted by the RP in the year 2017 and in the year 2020, say the liquidator admitted the amount and paid the amount. That is sufficient. That is also an acknowledgement, and that revives the
the limitation period. The period during which the company is undergoing CRP or liquidation is not included for limitation purpose, and the limitation period will get revived by that period.
Madam, can you please give a cash flow in this case?
I don't have it readily, but I can give that.
Because NCLT cut off, they did not agree that the period, the CRP and liquidation period should be excluded. They did not agree. Then my point was that as it is acknowledged by the liquidator, then it should at least revive. Then their point was there whether liquidator is a agent of the corporate debtor. If it is not an agent of corporate debtor, then it can also cannot revive cannot be treated as acknowledgement as per section 18 of Limitation Act.
I will provide you, sir. Just let me know your good name, please.
Sarabindu Jena.
Sir Binduji, can you just write an email to me reminding that? I will share that.
Ma'am, please give your mail ID.
My ID is harmeet.kaur@rrinsolvency.com. I will write that in the chat box, right?
Okay,
so
okay,
okay.
Okay,
there's no spelling mistake as well.
Thank you, ma'am.
Okay. So during the moratorium period, any legal action or proceeding pending in respect of any debt shall be deemed to have been stayed. The creditors of the debtor shall not initiate any legal action or proceedings in respect of any debt. So these two were there in the interim moratorium period as well. Now the third point is added during this moratorium, that the debtor shall not transfer, alienate, encumber or dispose of any of his assets or his legal rights or beneficial interests therein. Right? There may be a withdrawal of application which shall be as per Rule 11 of the insolvency rules. The AA may permit withdrawal of the application submitted under Rule 6 or 7 referred above. Before its admission on a request made by the applicant, after its admission on the request made by applicant, if 90% of the creditors agree to such withdrawal, an application for withdrawal shall be in Form D. Now, this is very interesting. Somehow I find it very interesting that RP is not, duty bound to issue public notice and all that. So the public notice for claims from the creditors shall be issued by the AA within 7 days of passing the order of admission under Section 100, inviting claims from all the creditors within 21 days of such issue.
Hello, can I come in? Hello.
Yes.
Hello.
Yes, sir.
Yeah, technically, yes, what you're saying is AA is supposed to issue a notice,
Yeah,
but practically
actually,
AA directs the RP to
I
issue
know,
the
I
notice
know.
on their behalf.
Exactly.
And then actually your work increases because
Yes.
then you have to, after the notice, you have to actually file an affidavit and give it to them saying that you have
Yes,
done
so
all
that
these
is
things.
what is the practical intricacy here.
Yeah, so actually it is,
That needs for
more
some
cumbersome, I would put it that way.
Yeah.
Okay, thank you.
So the law has been written in such an interesting manner here. So
Yes.
that's why I find it interesting. So the notice under subsection 1 shall include the details of the order admitting the application, particulars of the RP with whom the claims are to be registered, and the last date for submission of claims. The notice shall be published in at least one English and one vernacular newspaper. So this is all, no, this is not similar. Here also, affixed in the premises of AA and placed on the website of AA. So here they have just replaced RP with AA. Registration of claims of the creditors. The creditors shall register claims with the RP by sending details of the claims by way of electronic communication or through courier, speed post, or register letter. In addition, the creditor shall provide to the RP personal information and such particulars as may be prescribed. The list of creditors shall be prepared by the RP under section 104. A creditor shall submit his claim along with proof to the resolution professional in Form B on or before the last date mentioned in the public notice. The RP shall prepare a list of creditors within 30 days from the date of public notice on the basis of the information disclosed in the application filed by the debtor and claims received by the RP under section 102. The RP shall serve a copy of list of creditors to the guarantors, creditors, and file a certified copy with the AA along with the repayment plan. Repayment plan and approval by the COC. The debtor shall prepare, in consultation with the RP, a repayment plan containing a proposal to the creditors for restructuring of his debts or affairs. The repayment plan shall include the following: justification for preparation of such plan, reasons on the basis of which creditors may agree upon the plan, provision for payment of the fee to the resolution professional, such other matters as may be specified. The report on the repayment plan. The RP has to then submit his report on the repayment plan along with the said repayment plan before the AA within a period of 21 days from the last day of submission of claims. The report shall include that the plan is in compliance with the provisions of law. The plan has a reasonable prospect of being approved and implemented, that this is the same as feasible and viable. There is a necessity of summoning a meeting of creditors if required to consider the plan. If the RP recommends that a meeting of creditors is not required, he shall provide the reasons for the same. The report referred to in here shall also specify the date on which and the time and place at which the meeting should be held if he is of the opinion that a meeting of creditors should be summoned. The date on which the meeting is to be held shall not be less than 14 days and not more than 28 days from the date of submission of the report. The RP shall consider the convenience of creditors in fixing the date and venue of the meeting of the creditors. So B makes it difficult to implement A. Am I right?
Yes, ma'am.
Okay.
And in fact, the other thing which I want to say is, the regulation gives 21 days time.
Yeah.
And most of the creditors, at least my experience has been, they don't file it on time. And now they want the RP to, consider something similar like CIRP, condone the delay. So,
And ma'am, one more point here. There is some sort of confusion regarding the advance notice to be given for the creditors, for summoning the creditors meeting. So at one place, it has been said that 14 days of advance notice needs to be given. If we look at the regulations and the act, in the act, I think 48 hours of prior notice has to be given. So I'm handling a case personally, at the moment live. So recently just 2 days ago, I have conducted the first creditors meeting, giving 14 days advance notice. So would you like to clarify on that? What's
I will just,
period?
yes, I will just see that just now. I'm let's take a break of 15 minutes. As far as I remember, the 48 hours is for the associates, I think, associates of creditor, if I'm not wrong. Let us just check the regulations and come back and we meet here.
Yes, please.
At 11.
Thank you.
Okay.
Yep.
Thank you.
Thanks.
Anjali, shall we take a break of 15 minutes? We are having a homework to do in that break. Anjali is herself on a break. So let's meet at 11, right?
Sure. Sure.
So we start.
Yes, madam.
Yeah. So I've just checked the regulations and I was right. It says Regulation 11, Sub-Regulation 3 says the resolution profession shall convene the first meeting of creditors in accordance with subsection 1 of section 107 and shall convene the meeting by giving such notice to the other participants as decided by the creditors, which shall not be less than 48 hours. Right? So other participants which are suggested by the creditors, which are referred by the creditors, they shall not be given less than 48 hours of.
Whether participants has been defined anywhere in this?
No. So
Okay.
creditors may have their maybe ARs or maybe having their legal persons along, or any other participant which is decided by the creditors only. So let's start back to the procedure.
But the code says 14 days, right?
Yeah, that is for the creditors.
Yeah.
For any other participants, if it is decided during those 14 days that some request has come from some segment of stakeholders that maybe promoters have requested and creditors have agreed, or creditors have decided to bring somebody on those meetings. So
it's a one-way traffic. Borrower has no right to include any participant. Is it not violation of like?
no, they have not restricted the borrower. They have, but the meeting of creditors, the creditors will have a prerogative whether to allow somebody to that meeting or not.
So I think this is discrimination, and
so when this will pose the practical challenges, I think this will also get changed during the course.
Yeah, because
it is.
Discriminating among this between the creditor and the borrower.
No, I don't think there's a discrimination because borrowers are there. They are the individuals. So you don't expect any legal counsel or other persons to be nominate.
Why he can't engage legal counsel? He must be pleaded. He must be represented. He should have right to represent through legal counsel or chartered accountant who's a professional. If he is not literate, if he is not legally sound, legally literate or commercially literate, then he should engage and he should have right to engage somebody else to attend the meeting.
No, absolutely not. I would say there is a Kochi judgment also that in case, borrowers, whoever has borrowed such huge sum of money, they are commercially sound people. Okay. So the point which I think Harmeet Kaur and are saying is there is a system where you can, for creditors, they can send, ask proxies to attend the meeting. There's a form of proxy also, if I see the regulations. So it is in those cases that 48 hours are applicable. Okay. So it is for them, in my view, it is for them that notice has to be given at least 48 hours before.
But I think the other participants shall also be allowed.
Correct. Yeah. So not in case of borrower, he himself has to be present because he is the guy. Okay. Then tomorrow he will say if he asks him also to give his authority to someone else, then that will be a mockery of justice. Then he will come back and say he doesn't have any authority. He has to take his...
No. I think you have misunderstood this view. I am just telling that borrower as well as his legal counsel or chartered accountant should be also allowed to present.
And I think the other participant, as decided by the creditor, shall include the meaning they were in, that the creditor shall have a prerogative in saying yes or no to the request of the borrower in bringing somebody along. Like in the COC also, the participants are allowed to participate. The extra participants who are not there under the code or regulations, they are allowed to participate by the COC only after a specific request has been made and they allow. Yeah. So I think the process will evolve. There won't be an injustice of that kind as you are thinking, sir. Right? So let me just give me 1 second and I'll just close the doors here. Let's move. Rights of secured creditors in relation to a repayment plan. So this is a very important section, section 110. Secured creditor shall be entitled to participate and vote in the meeting of creditors. If he participates and votes in the meeting in relation to the repayment plan, he shall forfeit his right to enforce his security during the period of implementation of that repayment plan. Where he does not forfeit his right to enforce security, he shall submit an affidavit to the RP at that meeting where the repayment plan is being considered and being voted upon, that the right to vote exercised by him is only with respect to the unsecured part of his debt, and the estimated value of that unsecured portion of his debt. In such a case, secured and unsecured part of his debt shall be treated as separate debts. If he does not participate in the voting on the repayment plan, but the provisions of repayment plan affect his security, his concurrence shall be obtained. I hope it is clear.
I had a query. Suppose the value of the asset is say 50 lakh, okay, and the loan is say with interest is 1 crore. So how much would you treat it as a secured debt?
Please come again. Sorry, I missed.
See, the value of an asset,
yeah,
especially a flat, is say 50 lakhs, and the loan outstanding loan and interest amount is say 1 crore against that debt, against that flat. So you would treat the entire amount as secured debt or unsecured debt?
The value shall be considered, right? So the secured and unsecured parts will be the estimated value of these two parts shall be given by the secured creditor himself, and I think it will be 50-50 in this case.
Okay.
And the meeting of creditors that is given under Regulation 11, a creditor who is included in the list of creditors shall be entitled to participate. The voting share shall be in proportion to the debt owed to such creditor. The resolution professional shall convene the first meeting of creditors in accordance with so-and-so. We have just read it. And by giving notice to other participants as decided by the creditors, which shall not be less than 48 hours. The resolution professional shall convene a meeting of creditors on a request by creditors having 33% of the voting share. The notice under this regulation shall be served on every participant at the address provided to the resolution professional in accordance with Regulation 12. Unless otherwise provided in the code, any decision of the creditors shall require approval of more than 50% of voting share of the creditors who voted. Contents of the repayment plan. Under Regulation 17, the repayment plan shall contain the term, its implementation schedule, including amounts to be repaid and dates of repayment to creditors, the source of funds that will be used to pay resolution process costs, and such payment shall be made in priority over any creditor. A minimum budget for the duration of the repayment plan to cover the reasonable expenses of the guarantor and members of his immediate family to the extent that they are dependent on him, provided that at least 10% of the realizable income of guarantor shall be utilized for repayment of debts. Financing required for implementation. If the guarantor has any business, the manner in which it is proposed to be conducted during the course of implementation of the repayment plan and the role of the resolution professional. The manner in which funds held for the purposes of repayment, invested or otherwise dealt with, pending repayments. The functions which are to be undertaken by the RP, including supervision and implementation of the repayment plan, variation of onerous terms of contract or transaction involving the guarantor, the details of excluded assets and excluded debts of the guarantor, and terms and conditions for the discharge of the guarantor. Purchase of assets by certain persons. Under Regulation 18, the following persons shall not purchase or acquire any interest in the property of the guarantor directly or indirectly without permission of the AA, the resolution professional or any partner or director in the IPE of which the RP is a partner or director, any professional appointed by the RP for the resolution process, any creditor, any company where the guarantor or a creditor is a promoter or director, any associate of guarantor, creditor, or resolution professional. So here associate shall have the same meaning which is defined under section 79 as the associate of debtors. The AA may set aside purchase or acquisition made contrary to the provisions of this regulation and may make such as it may deem fit. Approval of the repayment plan. The repayment plan or any modification to the same shall be approved by a majority of 3/4 in value of creditors present in person or by proxy and voting on the resolution in a meeting of creditors. So this is not the value of entire debt. This is the value of those creditors who are voting on the resolution. The RP shall prepare a report of the meeting of the creditors on repayment plan, giving details of whether repayment was approved or rejected, the resolutions proposed, and the decisions on the same. The list of creditors present or represented at the meeting. The RP shall provide the copy of the report of the meeting of the creditors to the debtor and to the creditors present or absent and to the AA. Approval of repayment plan by AA, that is section 114. On the basis of the report of the RP on meeting of creditors, the AA shall approve or reject the plan. Where a meeting of creditors is not summoned, AA shall pass the order based on the RP's report submitted under section 106. The order of the AA approving the plan may also provide for directions for implementing the repayment plan. Where the AA is of the opinion that the repayment plan requires modification, it may direct the RP to reconvene a meeting of the creditors for considering the plan. Now, what is the effect of the approval of repayment plan by the AA? Section 115, where approval of repayment plan has been granted, such repayment plan shall take effect as if proposed by the debtor in the meeting and shall be binding on the creditors mentioned in the repayment plan and the debtor. Rejection of repayment plan by adjudicating authority, that is section 115, where the adjudicating authority rejects the repayment plan, the debtor and the creditors shall be entitled to file an application for cancellation. A copy of order passed by the AA shall be provided to the board for the purpose of recording an entry in the register. So here, one of the major differences is there is no forced liquidation. Liquidation is called bankruptcy in case of individuals. And my senior partner, Mr. Nilesh Sharma, he'll be taking up the next session on the bankruptcy rules and regulations. So here we are not the individual insolvency resolution process. If the plan fails or the plan is rejected, even thereafter, the creditors have a choice to settle or take the other route or to file an application for bankruptcy of that particular personal guarantor. Implementation and supervision of the repayment plan. The resolution professional appointed shall supervise the implementation of the plan. The RP may apply to AA for directions for particular matters. The AA may issue directions to the RP on the basis of such an application. When does the plan complete? The resolution professional shall within 14 days of the completion of the repayment plan forward to the persons who are bound by the plan and the AA the following documents: a notice that the repayment plan has been fully implemented and a copy of a report by the RP summarizing all receipts and payments made in pursuance of the repayment plan and the extent of the implementation of such plan. If in the opinion of the RP, the guarantor has failed in the implementation of the plan, the RP shall within 3 days of knowledge of any such failure issue a notice to the guarantor, identifying the failure and requiring him within 14 days of the receipt of the notice to address such failure if it can be addressed, provide an explanation for the failure. If the guarantor within the period specified under subregulation 1 addresses the failure in implementation of the plan or provides a satisfactory explanation for such failure, the RP shall report the failure to creditors within 7 days of the date of failure addressed or explanation provided for such failure. In cases not covered under subregulation 2, the RP may apply to AA under subsection 2 of section 116 for directions if he is of the opinion that the failure will affect the implementation of the repayment plan. Discharge order, section 119. The resolution professional shall apply to the AA
Good morning.
for a discharge order in relation to the debts mentioned in the repayment plan, and the AA may pass such discharge. The repayment plan shall provide for an early discharge or discharge on the complete implementation of the repayment plan. So please keep yourself on mute. Application for discharge order. It is given under Regulation 21 of Insolvency Regulations. The RP shall, for the purpose of discharge order, file an application along with the copies of notice and report under Section 117 to the AA under Section 119. On consideration of the notice and the report under Section 117, the AA may pass the discharge order. So here comes the judicial pronouncements.
Madam, just a query here.
Yes.
We have been talking about this repayment plan here, and code provides for after receipt of repayment plan, what are the actions to be done? If the repayment plan does not come up for XYZ reasons, what should the RP do?
Then the RP should report that to the AA, and creditors will still have the option to go for either bankruptcy or for any other ways of settlement with the by way of negotiation with the debtor.
In which provision should the RP report the matter to AA?
See, he does not have any other choice here.
Any specific section or regulation for the same?
I don't think that has been clearly provided. If there is no plan or if I have not missed any section, I think all of them are covered now. Then it shall be decided by the creditors in their meeting itself. And RP shall take the direction from the creditors only, because creditors have already taken over. The meetings are already being conducted, and thereafter
no, madam, the section says the first meeting of creditor has to be called after the receipt of the repayment plan. So RP cannot call for a meeting until he receives a repayment plan, in my opinion. That is a technical issue here. This has been, we have been actually dealing with this practically, so just wanted to clarify here.
Okay, so I'll add that to my practical difficulties slide, this issue. So I think the best course of action for you would be, because the law intends to give an option to the creditor to settle with the debtor in one way or the other. So the settlement option is still there with them, and RP should, I think, inform the AA about the status.
Yeah, we were looking for some specific section or regulation for the same. That was the query.
I'll check the regulations once again for this purpose. I think we are missing it somewhere. I've read it.
No, there is a regulation for non-cooperation, that is Regulation 22, that the RP can report the non-cooperation. But for what if the repayment plan is not there, what kind of a direction can be sought and under which section or regulation?
Right.
That is the query here.
Okay, I'll note this down, and please let me know on the email. I'll respond to that.
Yeah. Thank you.
Yeah, thank you. So in this matter, the NCLT rejected the creditor's application on the basis that a CRP was not pending against the CD. The creditor preferred an appeal to NCLAT, and NCLAT held that IRP could have insolvency resolution process could have been initiated against the personal guarantors, regardless of whether a CRP has been initiated against the CD. The NCLAT further explained that an application initiating insolvency against a personal guarantor can be filed before AA having jurisdiction over the registered office of the principal corporate borrower. Thereafter, the personal guarantors challenged the order of NCLAT before the Supreme Court, which confirmed the ruling and reasoning adopted by the NCLAT. It was held by the Apex Court that the initiation of insolvency resolution process against the personal guarantors to a CD are governed by the following principles. That is, a creditor can initiate CRP, not the CRP, IRP against the personal guarantors to a CD prior, during, or after the completion of CRP against the CD. An insolvency resolution process against the personal guarantors would have to be filed before an NCLT, which has a territorial jurisdiction over the registered office of the CD and not a DRT. So these were held very clearly. This is August 2023 judgment only. In federal laws, we are all aware about this matter. The NCLAT held that it's not necessary to initiate CRP against the principal borrower before initiating insolvency process against the corporate guarantors. It is always open to the financial creditor to initiate insolvency process under Section 7 against the guarantor without exercising the same against the principal borrower. In this matter, what happened was Mr. Saraf was a personal guarantor for the loan obtained by Factor Power from REC. While the loan agreement was signed on 22nd May 2009 and amended in 2010, 2013, and 2014, the deed of personal guarantee was executed in 2009. The loan was also secured by a corporate guarantee by Ferro Alloys Corporation. However, Factor Power failed to repay the loan, and in May 2017, REC initiated CIRP against Factor, that is Factor Power. This resulted in a resolution plan submitted by Sterlite Power Transmission Limited in 2019. The resolution was also approved by the NCLT bench at Cuttack on 30th January 2020. On November 2020, NCLAT dismissed the appeal filed by promoters. Even the Supreme Court rejected the appeal filed by the promoters against the order of NCLAT. Meanwhile, REC issued a demand notice for recovering its dues worth so-and-so in September 2020. And this demand notice was to Mr. Vineet Saraf. Mr. Saraf challenged the demand notice before the Delhi High Court, contending that he does not owe any debt to REC and that the demand notice issued to him should be quashed. The bench observed that there are sound reasons for not entertaining a petition before a writ court, where the relief being prayed for can be sought from statutorily established forum, that is the NCLT, NCLAT. If the writ courts routinely grant relief which could have been sought from an alternate forum established by way of a statute, the court in effect obviates the will of the parliament. They further held that the principal debt persists and has never been extinguished. It is therefore the case for the assignee that the assignee can recover the unrecovered part of the debt from Factor Power, that is a principal borrower, and the respondent in the instant petition is also attempting to recover the unrecovered part of the debt. In a petition praying for a writ of prohibition, where a petitioner is to demonstrate the absence of jurisdiction, the court does not consider it fit to develop, if at all this is a case for that to take place, an area of private contractual law, and then to use that development in order to establish a want of jurisdiction on the part of respondent, while dismissing the petition filed by Mr. Saraf. Here is that matter where we were talking about a family trust where they had decided to relinquish personal guarantees. In the matter of SVA Family Welfare Trust and in the matter of corporate debtor Ujas Energy Limited, the financial creditors decided to relinquish the personal guarantees given to secure the financial assistance granted to the CD by the financial creditors on payment of a particular value in the resolution plan itself. Right, sir? I don't remember who raised this. The Honorable NCLAT held that the judgment of the Honorable Supreme Court in Lalit Kumar's case cannot be read to mean as laying down law that personal guarantee never can be discharged in a resolution plan. The recent judgment in Edelweiss Assets Reconstruction Company Limited and NCLAT fully supports the submission of the appellate that security interest of dissenting financial creditor by virtue of personal guarantee of the ex-director of the CD could have been very well dealt in the resolution plan. The decision of the COC to accept the value for relinquishment of personal guarantee was a commercial decision of the COC, which cannot be allowed to be impugned at the instance of dissenting financial creditor. So the order of NCLT was set aside. So, sir, I hope this resolves your query. The dissenting financial creditor's interest is also being taken care of within the resolution plan, and the personal guarantee of ex-director has been dealt with in the plan itself. In this matter, Ramkishan versus other, in this matter, Honorable Supreme Court held that the liability of the guarantor or surety is coextensive with that of the borrower. Therefore, the creditor has a right to obtain a decree against the surety as well as the principal guarantor, principal borrower. Guarantor cannot dictate terms towards the same. In the Piramal matter, the NCLAT held that there is no bar in IBC for filing simultaneously two applications under Section 7 against a principal borrower as well as a corporate guarantor, or against both the guarantors. However, once for the same set of claim application under Section 7 filed by the FC is admitted against one of the CD, second application by the same FC for the same set of claim and default cannot be admitted against the other CD. So, this is with regards to the corporate guarantor. Asana Energy, I think we have covered already. The NCLAT expressed a view contrary to the view in Piramal case and held that simultaneous initiation of CRP against a CD and its guarantor is permissible. The NCLAT also held that simultaneous remedy is central to a contract of guarantee, and where principal borrower and surety are undergoing CRP, creditor should be able to file claims in CRP of both of them, and IBC does not prevent this. It's only that they cannot recover the amount more than the total settled debt amount.
Harmeet ji, you told me earlier that there is a judgment in respect of trust that the guarantor can be absolved in the resolution plan. So, yeah. Can you show me that judgment?
Yes, I was searching you while we were talking about SBA Family Welfare Trust. Herein, the security interest of the dissenting financial creditor by virtue of personal guarantee of ex-director of the CD has been dealt with within the resolution plan. So this is the judgment. You can get this, I think, on IBBI also. SBA Family Trust and another versus Ujas Energy Limited and others. Right, sir?
So even if suppose the lender is not agreeing for this resolution plan, suppose there are two types of lender. One lender is say 70% stakeholder, another is 30%. And 70% approve the resolution plan and 30% does not approve, because in that resolution plan it is mentioned that the guarantor will be absolved. So in that case, the 30% lender, can he approach to the NCLT to annul this resolution plan, because as the settled law that the guarantor's liability is coextensive and the resolution plan cannot annul the
there are two different concepts being taken up here in this your question, sir. If we consider the resolution plan approval process under the CIRP, wherein more than 66% is vote is given for the approval of the plan, right? So there the regulation of 38(1)(b), that is the amount, and the relevant section 32(b), whatever that is, the amount that has to be given to the dissenting creditor, which shall not be less than the liquidation value, that rule shall prevail here. Right?
No, I think it's the contrary. It's the contrary, because the lender itself is denying for the resolution plan because their entire money has not been repaid through the resolution plan. So he is asking the guarantor to pay his balance amount, which has been haircut for the under the resolution.
He can very well go to because if he thinks that his interests are prejudicially affected by the approval of this resolution plan, he can very well go in an appeal. But the law is settled in this case that the dissenting financial creditor cannot get more than the liquidation value. Secondly, the plan once approved by the COC.
I'm madam, I am again asking same thing, that not the liquidation value. Here the question that the invoking the guarantee or filing the application against the guarantor for taking the balance money which has not been repaid through the resolution plan.
So he can go to the for an appeal against the plan approval, right?
The plan itself is invalid, na? If its plan goes against the law.
No, madam, if the resolution plan is approved by COC by
then the commercial wisdom will prevail.
Yes, that will prevail.
Commercial wisdom cannot prevail the law or the constitutional law.
Exactly. In that case, in ARSS Infra Projects Private Limited, the same plan was approved by 86% of votes, and PNB and another bank they're 14%. I appeared for them, and the same thing I just raised, that this is against the law, and NCLT accepted that, and they went to NCLT. Then what NCLT did? NCLT then sent that proposal again to because these are secured creditors and there are sufficient personal guarantee. That we explained to NCLT that by invoking personal guarantee we can recover a lot amount. So NCLT returned that resolution plan again to the COC for their consideration, so that the personal guarantee of the dissenting creditors can be released. In this way, this has been in the case of ARSS Infra Projects Private Limited. This has been done.
Yes. So an appeal can be filed, and on the basis of that particular case, the outcome will come.
But madam, one thing that my fellow colleague was telling, that relinquishment of personal guarantee is against the law, and that violates the section 30 subsection 2 of resolution plan, because that resolution plan is not as per the law. If that is not the commercial wisdom, that's what we understand.
Sir, if you look at the from the other angle,
because that is not the guarantee, because the personal guarantor, this is, as you told, that resolution plan is a contract between the creditors and the corporate debtor and the corporate debtor. That is not
the resolution applicant, rather.
Yes, a resolution applicant. Yeah. But personal, we cannot include in that contract. We cannot take personal guarantors, and we cannot release personal guarantee.
Sir,
that is against the law.
No, it is not against the law. It can be made a part of the plan, and if the plan is approved by the COC, thereafter you can go in an appeal stating the relevant facts of the matter, and in case there is a value in the personal guarantee and the interests of the other secured creditors are getting affected by that, then definitely the appellate will take care of those facts. And
why, madam? Why NCLT? Why not NCLT itself? NCLT itself should reject the resolution plan if goes against the law as per the settled law.
If it is not yet approved by the NCLT, then you will go to the NCLT against the decision of the COC.
Sardendraji, how can you say that COC commercial wisdom is against the law?
Yes, you cannot say that.
No. That is something against. No. COC as per commercial wisdom, they cannot take any decision. It is established that this is against the law. But what madam is telling, that is separate thing. But this is against the law.
No, sir, this is not against the law.
Sardendraji, can you write?
Why is it against the law?
Sardendra, Mr. Janaji, can you write the name of this law? Can you write in the chat box?
ARSS Infra Projects Private Limited. In that also I appeared, and this was particularly my argument, and on that basis it was rejected. I will share this.
Sardendra, can you write in the chat box about the name of this? Please. Thank you.
I'm writing.
So, sir, how is it against the law? Can you just explain that viewpoint?
Yes, madam, that was the particularly that in the resolution plan, Personal guarantor, that is the liability of personal guarantor, that is separate. That is a separate agreement. This is the financial creditors or the COC, they do suppose 100%. Suppose, madam, 100% creditors, 100% creditors that take that decision unanimously. Then there would not have been any dissent. So in that case, whether it is legal or illegal, that matter will not come. But suppose a 1% creditor, he does not agree with that, then in that case it is illegal, completely illegal.
No, sir, not agreeing does not make it illegal, sir. The COC and the percentage on the basis of percentage of voting rights, they are allowed to.
Difference between commercial wisdom and legality.
So
commercial wisdom is separate. Legality, this is not a contract at all. This is outside your purview. So when something is outside your purview, how can you take that decision? Exactly, this was madam, this was my argument, and on this basis, ARSS Infra Projects Private Limited only particular on this basis. That was rejected, and they went to NCLAT. NCLAT what? And they also appointed, NCLT Kotak appointed a liquidator immediately. And then they went to NCLAT. NCLAT, then what happened? After hearing, they returned that resolution plan again to the COC for their consideration and for release of personal guarantee in favor of dissenting creditor. Suppose assenting creditor, they want to relinquish their interest in personal guarantee, that's okay. But they cannot impose their wish on the dissenting creditors.
Correct. Nobody can extinguish the legal right against the borrower. Yes, you're right.
Okay, let's go through that judgment of NCLAT also.
Yes, ma'am.
Yeah.
Share in the chat box also, name of the case.
Okay, I'm writing.
Yeah.
Could have been the case that the guarantee is available only for dissenting creditors.
Sorry?
It could have been the case that guarantee is available only to dissenting creditors.
Yes, exactly. Yeah, yes. Because a simple point, suppose 100% guarantee creditors, they agree to something, then there is no point of legality or illegality. But if somebody disagrees.
Sir, I think this is the question of law in this case would depend upon the value of those dissenting creditors involved in that PG and the rights affected by that the extinguishment of those guarantees in that particular resolution plan, and it cannot be made applicable to other cases like that. So it cannot be a standard principle, and it cannot be made a law that whether it can be dealt with in the plan or not. So it will be dependent on the case-to-case basis and will depend upon the facts of particular matter.
Yes, exactly.
Yeah, because there might be the value within that PG may not be much out of against the thousands crores of worth of loans. The value of properties of those creditors, those guarantors may not be much. So will have to be seen in the light of particular matter only. And how the rights are prejudicially affected, how the rights of the dissenting creditors are getting actually affected by that plan. So the main matter, Mr. Anil Ambani, etc., and 42 other big industrialists or promoters who have questioned the constitutional validity of the notification of the provisions of this chapter in respect of personal guarantors to the CD. It is pending before the Honorable Supreme Court. The questions are, Section 2, Subsection 3 of IBC does not allow the central government to make Part 3 applicable selectively to PG of CDs. The Chapter 3 applies to individuals and partnership firms as a whole. Second ground is granting opportunity to creditors to pursue two remedies for the same debt may give rise to possibility of unjust enrichment. Third ground of challenge is the debt of a PG coexists with that of the CD, and if the insolvency process is complete in respect of
Either of them. The claim will cease to exist against both of them. So, in this matter, an appeal under Section 62 of the IBC is against the final judgment and order dated so-and-so passed by NCLAT, dismissing the appeal against an order dated so-and-so passed by AA, admitting the application filed by respondent number 1 under Section 7. Maharaja Theme Park and Resort Private Limited, hereinafter referred to as Maharaja Theme Parks and Resorts, it stood guarantor for the loans availed by all the 3 borrowers. The borrowers failed to repay the debts payable by them to the financial creditor. And the Supreme Court held that under Section 7 of the IBC, CRP can be initiated against a corporate entity who has given a guarantee to secure the dues of a non-corporate entity as a financial debt accrues to the corporate person in respect of the guarantee given by it. Once the borrower commits default, the guarantor is then the corporate debtor. The issues raised in this appeal are settled by the court in Lakshmi Surana. As held by this court in Lakshmi Surana, the liability of the guarantor is coextensive with that of the borrower. The judgment in Lakshmi Surana rendered by a 3-judge bench of this court is binding on this bench. It was open to the financial creditor to proceed against the guarantor without first suing the principal borrowers. And here is the important judgment. I request you all who have not yet gone through this. I'm sure all of us have gone through this Lakshmi Surana versus Union Bank of India judgment. It is such an important judgment in respect of the limitation period as well. And I think somebody was asking about the limitation period, and this is the judgment for that purpose as well. In the said matter, Honorable Supreme Court held that the liability of a guarantor is coextensive with that of the principal debtor. That is now established. It gets triggered on the principal debtors committing a default in payment when it had become due and payable. The liability of the guarantor also gets triggered when the principal borrower acknowledges its liability in writing within the expiration of prescribed period of limitation to pay the acknowledged debt and fails to pay that debt within that period of expiry. For example, the 3 years of expiry of a particular limitation period is on March 31st, 2023. And within March 2023, the debt is acknowledged. Then the fresh 3 years period starts thereafter. As such, right to initiate action within 3 years from such acknowledgement of debt accrues to the financial creditor even against the guarantor. So these are some important outcomes of this judgment, and we must read this for our PG matters. Another important area which is open these days, those who are dealing with the with the PG matters, I'm sure they must be aware about this, but for the benefit of all of all of us, I'll just repeat the scenario, what is going on right now. A right of hearing is not given to the personal guarantors. And in the matter of Gurmeet Sodhi versus Union Bank of India, an RP was submitting a statutory report before the NCLT, and the Supreme Court of India has, as an interim relief, restrained him. It was granted after a petition was filed questioning the constitutionality of specific provisions of the IBC regarding the personal guarantor. The petitioner, a personal guarantor to a company, contends that the provisions violate the right of personal guarantor to be heard before acting upon the insolvency petition filed by the creditor and the appointment of RP. In the capacity of PG, one should be entitled to get a notice and to be heard by the AA, and non-adherence to the same, being the violation of principles of natural justice, is the conflict that arises.
Madam, just
yes.
Just previous slide.
Okay.
Lakshmi Surana.
I request all of you to please read this. This is a long judgment, but it will clear so many doubts regarding the limitation period, regarding the guarantor. We must read this judgment. There are some of them which are, I think, which are equivalent to the IBC for us. So the challenges that have been raised, which form the ground for this petition is, the first round of challenge was when the singling out of PG was challenged, with the lead matter being Lalit Kumar. The Honorable Supreme Court had dismissed the challenge and upheld the intelligent differentia between the individual and personal guarantors to the CDs. The second comes up with the petitions challenging provisions pertaining to the insolvency of PGs under the IBC, with the lead matter being Gurmeet Sodhi versus Union Bank, with Union of India, which is still pending. There is, of course, no doubt that there is something problematic about the provisions and their interpretation. And now we have understood that there are certain practical challenges also while implementing the provisions of insolvency resolution of the personal guarantors, which in a sense allow the appointment of RP against the personal guarantors without an opportunity of being heard to the PGs, which requires adjudication and determination by the apex court as well as the legislature. Even the section 420 of the Companies Act, which talks about the orders of the NCLT, talks about it that the tribunal may, after giving the parties to any proceeding before it a reasonable opportunity of being heard, pass such orders thereon as it thinks fit. Therefore, an opportunity of being heard is inherent, whether it is talked about or not. So our the regulations and the IBC provisions regarding the PG insolvency, they do not cater to that need. The tribunal may at any time within 2 years from the date of the order with a view to rectify the mistake apparent. So this is the section 420 and its subsection 1 is clearly applicable on this case. So the practical intricacies, I have listed a few, but I think we can have another slide by noting down what we have understood today. So I am taking note of all the challenges what we have just discussed during the course of this presentation. First, let us go through these.
Madam, one point.
Yes.
Just previous, as you told that keep relinquishing the personal guarantors in the resolution plan, that is not illegal. Then my simple question to you, suppose that IRP has already started against the personal guarantors before the initiation of CIRP. That is continuing. In the meantime, CIRP starts and the CIRP in resolution plan, creditors, they decide to put that clause, relinquishing the creditors.
Sir.
Then in that case, will the IRP against the personal guarantors stop?
No. In that case, sir.
That is the point. So sir, these are different. These are totally different cases.
Sir, that is
different from each other.
Sir, so, let me respond to this. Wait. While this IRP of a personal guarantor is going on, and in respect of the same debt, the CIRP also starts against the principal borrower, right?
Yes. Yes.
And while the IRP of the individual personal guarantor is going on, under that moratorium, you cannot have a simultaneous proceeding wherein an action is taken against the assets of the personal guarantor or his rights are affected.
Not affected. My simple point is that
so
will that stop?
Therefore, in this case where you are contemplating, in this case, in the resolution plan, the rights or the personal guarantee given or the responsibility of the personal guarantor, which is in respect of the same debt where CIRP is going on. So they will not be touched upon in that resolution plan because that portion is already being catered to by way of a different procedure going on.
Exactly, ma'am. That is my point, that these are completely separate from each other.
Yes.
And this is not within the purview of their personal guarantee, not within the purview of COC.
Sir, I think we cannot club all the scenarios within one sentence because whether it is within the purview of the COC, whether COC can approve such a plan will depend upon the facts of that matter particularly. In every case, the IRP of the PG is not going on.
Just single point.
Yeah.
Suppose SBI is the single creditor and SBI is in its commercial wisdom decides to suppose SBI decides to release the personal guarantors. then in that case, that will be treated as commercial wisdom of SBI. But if there are two SBI and PNB, and in that case, SBI, suppose SBI share is 80%. If SBI decides to release, that decision of SBI cannot be imposed of other bank, PNB. So that is the point that I have understood from the judgment of ARSS by NCLT and NCLT. That I have understood. That is the commercial wisdom. That is your commercial wisdom. Your commercial wisdom cannot be imposed on other, because this is beyond the you are taking some decision beyond your capacity. If you are releasing something, that is your wisdom. No, you cannot impose your wisdom on others.
Right, sir. So, in terms of interpretation of law and considering the facts of the matter, the advocacy of either side can be made, right? I'm not saying that that is legal or not legal. Any point can be advocated, and depending upon the circumstances, the facts of that particular matter, if the rights of the dissenting creditor or the minor creditor who has been left out, if his rights are getting prejudicially affected, if the relinquishment of extinguishment of the personal guarantees is not the best decision in that resolution, and in case by continuing those guarantees or enforcing those guarantees, or maybe initiating an insolvency resolution against those personal guarantor is a better and viable commercial decision, then that can be proved in the court of law, then definitely one has to go against that approval of the plan decision, right? So we do not conclude that it is legal or illegal. It will again depend upon the values and the rights affected, and how your interest is getting affected. So now the practical difficulties, which I'm sure I am also enlightened today, and I'll add 3-4 more of them after this slide. So I have jotted down that whether an opportunity of being heard should be given to the corporate debtor, that is the personal guarantor. Right now, we are giving that to the principal borrower, even if that is not allowed under the present set of laws. Even then, that is being allowed. So why not to the personal guarantor? So should that be inbuilt in the system itself, or should that be followed as a practice? Any views?
In my opinion, when Section 94 or 95, Section 95 application is made, then there is no requirement, because RP is appointed to give a report only. And that report, RP is a neutral person. And that only on that report, when he submits that report, then he is given the opportunity. So when a person is appointed to give a report, at that point of time, it is not required. That's my view.
Right. Anyone else? So my view is a limited window should be given. That should be inbuilt in the maybe regulations, or a few number of days, maybe 7 days can be given. But strict adherence to that time limit should be followed. It's not like the present system at NCLT, like no dates, no periods are mandatory. All of them are directory. So we should not proceed in that manner. But yes, some 7 days window can be given to them. Next problem is that against the crores of rupees, for suppose 100 crores rupees of loan is there for against a CD. And in the resolution plan, they are hopeful of recovering, or maybe even after liquidation, they are hopeful of recovering 40 to 50 crores of that, out of that. And they are taking a hit of 60% or maybe 70% or 40% of the haircut they are already taking. And then now they want to proceed against a personal guarantor. Considering the excluded assets, considering those in mind, do you think that 1 or 2 crore or maybe 10 or 15 crores worth of amount of the properties or the assets of the personal guarantor would help the lenders distribute that amount in front of the 60 CR or maybe 70 crore or maybe more than that of amount of haircut that you are already facing, or 100 crore is just a meager amount. Most of the CDs have wherein insolvencies or liquidations are going on. They are having debt not less than 1,000 crores. So would that 10 CR of a property by selling and invoking that enforcing that be sufficient to meet the huge amount of loans and the lenders are exposed already? So I don't think this will lead to some, great satisfaction for the lenders. But yes, there is a process, and as RPs, we should just conduct the process. So that is a practical problem that the economy is going to face very soon.
No, ma'am,
Yeah.
slightly, ma'am,
Yeah.
slightly one point.
Yeah.
It is not that one would recover anything from the promoters
Yeah.
or the guarantors, as we are saying over here.
Mhm.
It's more of a question of whether we want these people to go scot-free,
Yes.
or whether there is some sort of some sort of a responsibility to them,
Yes.
because ultimately this is a public money which is going into any kind of a business. So whether they should really so we have this section 66 and all these which is going on,
Yeah.
but simultaneously whether we need I mean, that's a separate
May I know your
section
name,
altogether.
please?
My name is Charu.
Charu ma'am, this is absolutely wonderful point you have raised. And actually this, after this notification of PG regulations, etc., there has been a threat amongst the promoters. And I think that will lead to some seriousness in their conduct. Right? While giving a guarantee, they'll think twice about the projections, about giving the correct kind of definitely the business projections, and they will carry out the essential checks on their own business requirements and the utilization of loan amounts, etc. But yes, the PUFE transactions and 19.2, they have not been successful till now, but this PG will have an impact on their mindset. I agree with you.
Yes.
But from the recovery point of view, ultimately बाप बड़ा ना भैया, सबसे बड़ा रुपया. So recoveries तो अभी it's not going to improve much. So third is the rupees 1,000 is bound to be changed to 1 lakh, and 1 lakh is the last limit. Then while conducting the process, RP has to take comments from the debtor. RP, the CD, the principal borrower, as you are aware, they never they are already having a corporate setup. They are having huge teams of people. Even then they don't bother to respond to the RP. They don't cooperate in the CRP process. So do you think that in the personal guarantor matter, where he's a singular person, he can always escape his answerability by saying that मेरी कोई balance sheets नहीं maintain होती है, I don't have accounts, मेरा तो कोई record ही नहीं है, I'm an individual, there is nobody supporting me, I don't have a structure, I am not an organized person or whatever. So they will have this plea, and RP will definitely go through more difficulties in practically implementing the extracting information from him. This is how I think about this situation. And now we have also gone through some we have also gone through some of the points being raised during the presentation, and I would love to add those right away herein. Yes. Anyone would like to raise those points?
Madam, I will come again with my question here.
Yes.
If the repayment plan does not come up for X, Y, Z reasons,
Yes.
what should the RP do? Because our discussion entirely has been based on the topic that repayment plan comes, and what should the RP do?
Yes. Another point was the AA does not, publishes. Let's not write this. Anything else?
No, that practically responsibility is being given to the RP only, I think, in the order itself, that the publication will be done by the RP.
So they have a practical solution to that.
Yes, yes.
Yes.
Yeah, ma'am, I would like to add one.
Yes.
Madam, if the decision of Supreme Court is not finalized for
I'm
2
from
years, 3 years,
PG to
then what
CD
will be the
case. Am
process?
I audible, ma'am?
Yes.
Hello?
Please tell your name, sir.
Am I audible?
Yes.
Yeah, my name is Narsimha Rao Kedari. Yeah.
Anji,
So the
Narsimha
thing
ji.
is practical. I just want to add. Yeah. Yes, please.
Yes, sir.
So I want to add one thing. So yeah, the creditors were recommending to appoint a private detective agency, debts or the claims being received from the creditors. So considering that the creditors wanted to go for appointment of a private detective agency. So if we compare this scenario with appointing, say,
Sir, your voice is breaking and I'm not able to hear the complete question.
other professionals in CAR,
I could not hear.
Madam, I am Vimal Kumar. I am just asking, what will the position if Supreme Court doesn't take decision for 2-3 years? Then what will be
regime? So, but if we
okay.
Mr. Narasimhan, your voice was breaking. You can put your question in the chat box itself, I think.
Anyone else? All right.
Hello, ma'am.
Yes.
Am I audible now?
Yes.
Yeah, ma'am. So the point which I was trying to raise is regarding the appointment of a private detective agency. If we compare this particular scenario with appointing, say, registered valuers or other professionals of CIRP, so it's individual insolvency resolution process. RP is not really bound or duty bound or statutorily bound for that matter to appoint a private detective agency or something like that, right? So, I mean, this is like a practical challenge. So when it comes this way, then the cost involved there has to be borne by all the creditors in their voting share proportionately. So the point which I'm trying to raise here is, I mean, there should be something specifically on appointment of professionals in the PG to CD matters as well.
Okay, right.
Yeah.
So I think
I have one question.
Just a moment, Ashish ji. On that point, if you appoint a professional for specific services which are required for the conduct of that IRP process, so I think that are going to form part of the costs, and there is no stopping. Nothing restrains that even in these regulations.
Yeah, but when it comes to the practical challenge of sharing the cost involved, then some of the creditors are okay with that, some of them will not be. Then
So
again, if it were similar to that of CIRP, that RP has to appoint, say if the registered valuers there, the RP's prerogative, he need to appoint and then he need to get along with that. But it is not the case in this one, right? So the practical challenge here is sharing the cost comes up on the head of the RP, and the detective agency will be back of the RP chasing him to pay the fee, and the creditors, there is a deadlock kind of a thing. So that is one of the practical challenge which is prevailing here.
Sir, a practical solution as we do it in the CRP also, we get those costs pre-approved.
Okay.
Right.
Okay.
So that is a practical solution. I think we have all learned during CRP also how to deal with the creditors and the COC and their own sweet wishes. So we will have to get those costs pre-approved. Otherwise, you don't go for any appointments, even if it is not in the best interest of the process. Because I don't think personal guarantor would share all the information
I don't think he'll be telling you where all he's having properties.
Correct.
So one thing for getting the details about the promoters, about the personal guarantors, you can take help from the FCs themselves, because at the time of lending the loan, they must have taken the net worth certificates, etc. of the personal guarantor. And even if that is related to maybe 10 or 12 years earlier date, we can always ask the promoter or the personal guarantor to show that the said property has been sold and it is not in his name. At least we can have a starting point of making the list of assets that he is having or something. So those practical solutions will have to be applied. I don't think the solutions will come from the IBC or the regulations. They just see everything in the plain black and white.
Got you. I think probably convening one another meeting and then taking all the creditors along with me in terms of approving the payment for that agency. That would be the right way.
They must pre-approve that, and we should have those minutes in signed.
Yep. Okay.
Mr. Narasimha, just one thing here. So I think you are in the insolvency resolution process as of now, or the bankruptcy process?
Yes, I am currently handling the insolvency. It hasn't gone up to the bankruptcy yet.
So should not we do this PDA kind of a thing in the bankruptcy process when we have more powers?
Yeah, that's one another point, sir. So somehow the creditors are pressing for this at this juncture itself instead of waiting till the bankruptcy process to kick in. So they wanted to, I mean, before voting on the repayment plan as an agenda item for voting, they want to come up with this report from the detective agency, and then they will vote on the repayment plan, is what their contention.
Okay, they want to find out the properties, if any hidden properties are there or not.
Yes, exactly.
So I think madam has just now said the same thing, that we should get it approved in the meeting itself, or they should conduct the PDA themselves.
Yeah. Okay, that's what I mean. Instead of taking it on RP's head, I mean, if RP has to front end it, then we have to be clear on who is funding that in what proportion.
Definitely.
If not, someone from the creditor side, the lead banker wants to take the lead in this matter as well and appoint, and then that should be okay with me. Yep, got you. Thank you.
Ma'am, I'm seeking a little help from you. We have seen this practical problem that most of these personal guarantors, what they do is their personal properties are involved. They get into lease agreements with their friends and all, and just show that one room here. They put in 4 or 5, false tenants. Actually, they are not tenants. Only the owner is living in the house just to make the property seem like disputed, to reduce the value. So what is the best solution for this? I mean, if you go to the court, it is a never-ending process, to get it vacated. So, I mean, how do the NCLT and courts view all this problems created unnecessarily?
Sir, as long as the documents are there, you will have to rely on them. If there is a lease agreement, you will have to rely on them on that. In case you can find out the documents are not registered or something, some deficiency is there in that lease, then only that could help you. Otherwise, you will have to take that into account, and whatever value is getting affected, that will get affected. So I don't think there is a practical solution to that, but you can always check and see the other supportings to that lease agreement, if that is complete in all respects, and while sanctioning the loan, maybe there was a covenant in the loan agreement that the PG is not allowed to lease, or something of that sort can be taken out for the help. I don't think the valuations, if the promoter is doing all those sort of it's not a matter of record, but the promoters do get it, engage themselves in such kind of activities, and the RP will have to go by the documents. You can only check the validity of those.
And if the rent is not paid, just simply a simple agreement has been written that leased out, and the person tenant is actually not living there, not using that property.
Those checks are applied, then you cannot take that into effect. Now you can go to the court, or you can take that up in the meeting of creditors, and the valuation will have to be then taken up accordingly. The value, whatever is being proposed for the estate or during the insolvency resolution process, the values will not get affected by that lease then.
Okay. Thank you so much.
A separate check will have to be applied.
SARFAESI Act has a better option for that such cases.
Sorry?
SARFAESI Act has better options for such cases.
Yeah, bankers have got more powers over there.
Yes.
But even then, banks are going for PG cases.
I don't think that if they are having security in the form of immovable property, they are opting for SARFAESI prior to PG cases.
Yes. SARFAESI is always preferable these days
Yes.
over the insolvency process. I don't know why they are so disappointed with the entire process, but most of the bankers are avoiding CRP and the but personal insolvency, I think that is going to gain momentum after this clarification comes from the Supreme Court.
Yes.
Yeah. Anyone else is having any?
Harmeet ma'am, I would like to add on this. Basically, only in those cases where the properties are mortgaged to the creditors, they can prefer the SARFAESI. There are certain other properties which also belongs to the personal guarantors. In those cases which are not directly mortgaged or given as a security to the financial creditors, in these cases, this personal guarantee process only can help the financial creditors to recover their dues from their other assets.
Yes.
So I feel that there is a still probable chance that the personal guarantee process may survive for a longer time.
Yeah. And I have also seen interest in the bankers for personal insolvency these days, because they are aware of the other properties which are non-mortgaged, which are not there on record, but they are aware that the properties are lying and we can find them out and at least some recovery can be made. Thank you everyone for contributing. Thank you Sigdarji. And anyone else if having any contribution for this subject, I'm sure we can now take up with our existing bankers. Wherever we are in touch with them, we can always convince them to, start the personal insolvency cases. And
one question is there in the chat box: is separate bank account required to open PG matters like CRP or
not provided in the regulations? So I don't think. But for facilitating your own process and transparency, you should go for that.
Okay, thank you, ma'am.
One thing, one thing. Just now, I think we received one query that if any plan cannot be prepared by the RP, then what action we should take? Basically, in this case, I think we must refer Regulation 22 of the personal insolvency case, where it is stated if we do not get any cooperation from the personal guarantor, we must refer it to A. So I think that should be the process, because if you are not in a condition to prepare due to non-cooperation or due to non-availability of complete information, definitely then we must write to A. Otherwise, also we should go to A. But the Regulation 22 is very clear on this matter. We must go to A for any such action.
Yes, sir.
Mr. Sikdar, we have already discussed this, and we have already filed the application under Regulation 22 itself, and the AA dismissed of the petition by directing the personal guarantor to cooperate with the RP. And RP repayment plan has to be given by the personal guarantor and cannot be prepared by the RP, no?
Yes,
definitely. That has to be given by the personal guarantor only in consultation with the RP.
So that's what I'm saying. We have tried this option also, and the just I told you that the whatever the application was there, that was disposed of by AA by giving direction to the PG to submit the resolution, the repayment plan. That's it. But he has not adhered to that also.
Madam, one thing, once a petition is filed and RP is appointed and report is being filed by RP, then they will admit or reject. Till that time, whatever the expenses are there, or fees will start only when it is admitted, correct? So till that time, who will bear the expenses?
The creditor should bear.
Because fees will start only after admission, no? Correct? No?
Yes. So if the engagement is by the debtor, then debtor will pay. If it is by the creditor, then they will pay. If it is by...
And any remuneration RP will get for this preparing report, etc. something?
Sir, RP will get it from the creditor who has filed, no?
No, remuneration, this fees, monthly fees, they will start paying? No.
Actually, that is a contract between you and the person who is appointing you. Definitely.
Yes, that is correct. One fees we have quoted, they have taken consent, form 4, etc. Petition is filed. Then that I am asking. After that, fees will start from admission or from that report itself. That
from your appointment itself, sir. You have given them guidance also, na?
Oh.
So it should be written clearly in your mandate to them, in your initial terms of understanding with them.
At the time of quotation, we cannot write, na? From that date.
No, but at the time of accepting, at the time of giving consent, you definitely should have very clear terms of payment. You should not give your consent in this capacity. You are a professional.
Is it visible in consent we have to write there?
Not in the consent, but at the time of giving consent, you must have some understanding with the person who is engaging you for any professional assignment. This rule should apply.
Okay. We'll see next time.
So may I request everyone to just switch on the camera so that I know that I'm not talking to the screen. Thank you for those who have kept it on already. And thank you everyone for the patient hearing and giving me also practical aspects of the matter.
Thank you.
Thank you, everyone.
Thank you for giving valuable
great session. Ma'am, it was a great session and interactive also. Thank you.
Thank you.
Thank you.
Thank you, Harmeet. Thank you.
Anjali, shall we close?
Thank you, Harmeet ma'am, for catering our request.
Can you please share the PPT?
Yes, I will. I'll send.
Thank you.
Yes, Harmeet ma'am. First of all, also, I would like to tell you that this side Surbhi from ICSI IIP this time. And I would like to place formal vote of thanks before all the participants for our today's faculty, Harmeet ma'am, who catered our request to be the faculty for the first session in this specific workshop. And the way you've conducted the session in such an interactive manner, seriously, it will give a lot of boost to all the participants to be in the new section of practice and personal guarantors. So it really means a lot for the ICSI IIP as well that we have such persons with us who motivate to take the profession to the next level. So thank you, Harmeet ma'am.
Thank you, Surbhi. Thank you so much for such motivating words for me as well.
Yes, thank you so much, ma'am, for being with us for these 3
I
hours.
have not seen you, Surbhi. This is against the rule of the game.
Yes, ma'am, this is against the rule of the game. So I will not break any kind of rule. So I'll just on my video. Just give me 2 seconds.
Yeah. So here we don't insist participants to switch on their cameras, and with ICSI, where I'm a regular speaker, I don't start talking only because they won't get attendance if they don't switch on their cameras. So that is the precondition over there. But here I understand we are double professionals. So all IPs consider themselves, and they should consider themselves to be professional raised to the power 2. So we are allowed to switch off at our convenience. So Surbhi, once you switch it on, I'll take a screenshot.
Ma'am, I've already switched on my video. It's not visible?
No.
I don't know, but I have.
No problem. No problem.
Yes, you can take the screenshot with written ICSI Institute of Insolvency Professionals. I think that's my reference, I would say. Meri pehchan hua.
Sure. Thank you, everyone.
Thank you, participants. Now we'll meet 1:30 sharp with the next session with Nilesh Sharma.
Thank you.
Thank you.
Thank you, sir.
Thank you.
Thanks a lot.
Thank you. Yes, please.
So participants, welcome back to the second session of this workshop where we have Nilesh sir with us to have discussion on the topic bankruptcy process and personal guarantors. He's going to take the discussion that we had in the first leg forward. I would like to read his brief profile before all the participants. He's a commerce graduate, chartered accountant, a law graduate, registered insolvency professional, enrolled with ICSI. His practicing areas are restructuring and insolvency for over 25 years. He's been representing number of clients before different benches, NCLT and CLAD on regular basis. He's a member of INSOL India and is rated as one of the leading lawyers in the field of restructuring and insolvency by various reputed international journals like Legal 500, Chamber and Partners, Asia Law Profiles, etc. We welcome you, sir, in the second session of today's workshop. Over to you, sir.
Thank you. Thank you. 1 minute.
Good afternoon, everyone. Hope you can hear me.
Yes, sir.
Yes, sir.
Yes.
Yes, sir.
Good afternoon. So let me share my PPT, which has been prepared for today's session. Hope you can see it on your screen. Can you see it on your screen?
Not yet.
Yes. You can see the folder. The file is still not open.
Okay. 1 minute. Can you now see it on your screen?
Yes, sir.
Yes, sir.
Okay. So bankruptcy process relating to personal guarantors to corporate debtors. So that is our today's topic. And I think in the morning, you were having the session on insolvency resolution process for personal guarantors to corporate debtors. So as you are aware that with respect to individuals, we are having two processes, one insolvency resolution process and another process is bankruptcy process. In case of corporates, we have insolvency resolution process as well as liquidation process. So liquidation process and bankruptcy process, they are similar, except that in case of liquidation, the entity, the company is eliminated at the end of the process. It is dissolved. However, in case of bankruptcy process, what the final outcome is, discharge order to the debtor, to the individual debtor. Okay, so discharge order, why that discharge order is required to be given, we will understand that as to why should we give any discharge order. And discharge order, all of us know that it is an order by which a debtor is discharged from all his past debts, all his debts which are there as on the date of passage of that order or as on the date of bankruptcy commencement date. So he is relieved of all his liabilities. Okay, so why this kind of order is required? Why should we give him this type of order? We will understand when we go through this PPT. Let's start. First of all, definition of guarantor. Because as you know that presently, the provisions relating to the guarantors to the corporate debtors, only those provisions with respect to individuals have been notified. And the other classes of individuals and partnership firms have not yet been notified. Okay, so we will restrict our today's discussion to the to the guarantors, to the those individuals who are guarantors to the corporate debtor. So first of all, definition of guarantor. Guarantor is defined not under IBC, but guarantor, though there is a definition which is given under the rules also, but the definition which is provided under Indian Contract Act, that is the basic definition of this term: contract of guarantee, surety, principal, debtor, and creditors. All these things are defined there. And this is defined under section 126. A contract of guarantee is a contract to perform the promise or discharge the liability of a third person in case of his default. Okay, so it is not the liability of the guarantor. The liability is of a third person. And when that third person commits a default, then only liability of the guarantor arises, otherwise not. If the principal debtor, so three parties are there in the case of a contract of guarantee. So these three parties are: one, principal debtor, who has actually taken a loan or or who is having any obligations toward the creditor. So that is called principal debtor. Then we have creditor. So creditor is the person who is giving credit, okay, to the debtor. And third is surety, or we call him guarantor. So surety and guarantor. Surety or guarantor is the person who is taking the responsibility of performing the process or discharging the liability in case the principal debtor fails. Okay, so these three parties are there to a contract of guarantee, and these three parties, their role is that, let's see the definition. A contract of guarantee is a contract to perform the promise or discharge the liability of a third person in case of his default. Okay, so actual promise is made by, or the liability is that of the principal debtor towards the creditor, and surety says that if the debtor fails, then I will be performing the promise, or I will be discharging the liability. Now, I've already explained the person who is giving the guarantee is called surety. Person in respect of whose default the guarantee is given is called the principal debtor, and the person to whom the guarantee is given is called the creditor. A guarantee may be either oral or written. Then the guiding principles are provided under section 126, that first of all, that it has to be a tripartite agreement, or it may happen that there is a one contract for the provision of funds, and there is another contract for the provision of guarantee. So actually these two, there can be two agreements also, which constitute actually the contract between these three parties. Okay, so these three parties are surety, principal debtor, and creditor. Liability of guarantor is coextensive with that of the principal debtor. What is the meaning of the same? We are having a number of judgment on this particular statement, wherein liability of the guarantor is coextensive with that of the principal debtor. So the meaning of the same is not that if a principal debtor is taking a liability of rupees 100 crore, then guarantee must be for the amount of rupees 100 crore. The guarantor may say, or the agreement can be, the guarantor may undertake to guarantee only the debt to the extent of rupees 50 crore or 40 crore or 20 crore. Okay, so it is, the meaning of this term is not that. Meaning of this coextensiveness of the liability of the guarantor is not that all the debt of the principal debtor is guaranteed. It is to be determined by the contract which is there between the creditor and the guarantor. So this can be below the total amount of debt also. In some cases, we must have seen that a third party is providing some security for the debt which is being taken by the principal debtor from a creditor. And then the guarantee provides that the obligation of the guarantor will be limited to the value of that asset which has been given as a security. So this type of contract can also be there. Okay, then the guarantor's liability, we will be coming to this aspect of this law as to the co-extensiveness of the obligation of the guarantor. So we are having some judgment on that. Guarantor's liability to make good the payments on behalf of principal debtor arises as soon as the principal debtor fails to fulfill its obligation under the contract. So liability of a guarantor arises only when principal debtor fails to fulfill its obligations. So if suppose principal debtor is making the payment as agreed, as per the agreement by which some debt was extended to the principal debtor, in that case, till the time default is there, you can't ask the guarantor to make the payment. Creditor can't ask the guarantor to make the payment unless and until the principal debtor commits a default. Now, suppose the default has been committed by the principal debtor. After that, the claim can be made or the guarantor can be asked to make the payment. Only in that case can be asked to make the payment. And then in that situation, it is not necessary that the creditor has to proceed against principal debtor first, and then only he should proceed against the creditor, against the guarantor. So it is not necessary. Once default is there, then after that, creditor can proceed either against the principal debtor first or against the guarantor first or simultaneously against both of them. Okay, so on this aspect also, we are having certain judgments, which we will go through. The guarantee furnished by a person to the corporate debtor can be invoked even prior to resorting to the corporate debtor. So we are having, as I said, that you can even proceed against the guarantor after the default has been committed by corporate debtor. You need not proceed against the corporate debtor first. Now, the definition which is given under section 522, the definition is personal guarantor under the code is defined as an individual who is the surety in a contract of guarantee to the corporate debtor. So this is the definition of a personal guarantor, individual who is the surety in a contract of guarantee to the corporate debtor. We are having another definition also, which is provided under the rules. We'll see that subsequently. Now, extensiveness, co-extensive with that of the borrower. So this is Ram Kishan and others versus State of UP and others. So this is that judgment of Honorable Supreme Court, wherein Honorable Supreme Court said liability of the guarantor oblique surety is co-extensive with that of the borrower. So it is a judgment which came much prior to notification of IBC. Okay, so this is on the on this aspect of whether the surety can also be sued once there is a default, or you have to first proceed against the principal debtor. So on this particular aspect, this judgment is there. The creditor has a right to obtain. So both of them are equally liable. Surety or guarantor and the principal debtor, they are equally liable, though there may be some restriction as per the agreement that surety is not liable for the full amount. But to the extent surety is liable, so then the creditor can proceed against any of those. So their liability is co-extensive, though surety is entitled once he makes the payment. He is entitled, he steps into the shoes of the creditor. Then he becomes a creditor of the principal debtor. So that is another thing. But the creditor is entitled to proceed either against the guarantor or against the principal debtor. Creditor has a right to obtain a decree against the surety first, and the principal borrower surety first, and then the principal borrower. Guarantor cannot dictate terms towards the same. Guarantor cannot say that first proceed against the principal debtor and then you come to me. He can't dictate this type of term. Then Deepak Bhandari versus Himachal Pradesh State Industrial Development Corporation. This is another judgment of Honorable Supreme Court. It is also a judgment which came prior to issuance of this notification of this law of IBC. In this, the question arose when right to sue or to initiate insolvency process arises. That 2014, civil appeal number 1019/2020. The right to sue or initiate insolvency process arises. In this case, Honorable Supreme Court question arose that if the payment is being made by the principal debtor, whether you can proceed against the guarantor. So answer to that is no. Honorable Supreme Court held that the right to sue under a contract of guarantee, indemnity or guarantee would principally arise when the indemnifier or the guarantor fails to pay the money claim from it, and not from the time when the recall notice is served. So now why this date is important? So one is, we know the process that initially there is an agreement for the purpose of borrowing of some loan from the creditor by the debtor. Okay, and then there is a guarantor. There is an agreement with the guarantor. That guarantor is guaranteeing the repayment of that loan and interest thereon. Now, the principal debtor defaults. Principal debtor defaults. Principal borrower defaults. Then what happens? Then entitlement of creditor is there now to proceed against the guarantor. But how it is to be done? So then in that case, what happens is that you know that liability of guarantor is with respect to the default which is committed. So suppose there is a loan which has been taken from a bank by a borrower, and then the amount is to be repaid over a period of, for example, 5 years. There is a default in payment of one installment. Okay. So then the creditor, he becomes entitled to recover that amount, defaulted amount, from the guarantor. But whether he will be proceeding for that one installment and then again default, then again he will be proceeding against the guarantor. So answer is no. So what actually happens is, when this type of defaults are there, so it is not that at the first default only the banker will be initiating action for recovery. So they initiate discussion, and you know that account becomes NP only subsequently after 90 days of default. Okay, so if 1, 2, 3 installments are defaulted, then in that case, bankers, they try to resolve. They try to see that if the default can be cleared. If not, and they feel that now recovery action has to be taken. So one thing which they do is the recalling of the loan. Entire amount of loan is recalled, so that now they can proceed against the principal debtor as well as the guarantor in respect of the entire amount of debt. So not in piecemeal manner. So that notice, that is called recall notice, and that is a notice for termination of agreement also. So you know that in all the agreements we are having a termination clause. So this type of clause is there in case of loans also, in case of the documentation which is there for the purpose of providing loan to a borrower. And the bankers or the creditor, they invoke that clause, and then they say that now we have defaulted. So right to recall is when there is a default. Okay, so as per that agreement, they issue a recall notice. They ask the principal debtor to make payment of the complete amount within a specified period. So as per the agreement, so if suppose 15 days notice period is prescribed, then the recall notice will say that you have defaulted in making payment of such and such installment, and as per such and such clause, I am entitled to terminate the agreement and recall the complete amount of loan along with interest. So I am recalling the entire amount of loan. You are required to make payment within a period of 15 days, which is specified in the agreement normally. And if you don't make the payment, I will take recovery action against you. So this is recall notice. Now, once this recall notice is issued, after that they invoke the guarantee. If they invoke the guarantee prior to recalling of this loan, okay, so that invocation can be only with respect to the amount of default. not with respect to the total amount of loan. Okay, so recall notice is normally issued after the invocation of guarantee notice is issued after recalling of the loan, and after the time period which is given to the borrower for making payment of the recalled amount of loan is over. So if 15 days time period is given, then after that only there is a default for the complete amount. If you give the notice prior to that, if you invoke the guarantee prior to that, I think there will be a flaw in that. So you should, the creditors, they should issue the invocation notice after there is a default for the entire amount. Okay. So then suppose that 15 days period is over. Now invocation notice is issued by the creditor to the guarantor. And what is the meaning of invocation? Invocation is that now, because there is a default for the entire amount, I am asking you to make payment. I am asking you to make payment of this entire defaulted amount to me within a period of 10 days, 15 days, which is also normally specified in the guarantee deed. Okay, so that notice is called invocation of guarantee. Okay, so that notice is issued for invocation, and then guarantor, if he defaults, and because if he does not make the payment within the specified period, then after the expiry of that time period, suppose 10 days time period has been given for making payment, then after the expiry of 10 days, then there is a default by the guarantor, and your limitations start when somebody commits a default, when a right to sue arises. So in this particular judgment, Honorable Supreme Court said that right to sue the guarantor arises only when guarantor fails to pay the money claimed. Okay, and not from the time when recall notice is served. So recall notice is issued to the borrower, and in most of the cases the copy is served on the guarantor. So Supreme Court said that no, that is not a invocation. Default is not by the guarantor. Guarantor's default will be only when you invoke the guarantee, when you are after this default has been committed, you write to the guarantor to make payment, and when after that time period, expiry of that 10 days or 15 days time period, guarantor fails, then you are right to file a suit or to initiate any recovery action against guarantor starts. Okay, so the Honorable Supreme Court held that the right to sue under a contract of guarantee, indemnity or guarantee would principally arise when the indemnifier or the guarantor fails to pay the money claimed from it, and not from the time when the recall notice is served. I think some question, Mr. Jaina?
Yes, sir.
Yeah.
Sir, then limitation period against the guarantor starts from the date of invocation of guarantee or from the date of recall of notice?
Not from the date of recall notice, not from the date of invocation, but from the date when suppose in the invocation notice you say you ask the guarantor to make the payment within 10 days. So expiry of 10 days. After the expiry of 10 days, that means from 11th day, the limitation period will start. Not from the date of invocation, not from the date of recall.
Sir, okay. Suppose on 31st March 2023, the account became NPA. The
Correct.
default occurs on 31st March 2023. And
30th... one thing. NPA date is not relevant for the purpose of limitation.
No, that is the date of default, sir. NPA date is most important. That is the default date.
No,
that is
wrong. Wrong. I will tell you, Mr. Jaina.
NPA date is not the date of default, sir. Your
yes,
SMA 0, 1, 2 categories.
Yes, sir. Sir, I understand. But in NPA,
Mr. Jaina, let me explain. I'm totally aware of all these terms, NPA and everything. Kindly understand. NPA, an account becomes NPA after the expiry of 90 days. If it is a working capital account, it is out of order for a period of 90 days. If it is a term loan, then in that case, there is a default in making payment of any installment or interest for a period of 90 days. Okay, so default date is much prior to that. for the purpose of limitation, the date when actual default has taken place, that is relevant. The NPA date is relevant for other purpose, like under SARFAESI Act. NPA date is relevant for the purpose of issuance of that notice. You can issue notice under section 13(2) only when account becomes NPA. So kindly keep this thing in mind, that NPA date is not the date of default. Yes. Now, please. Yeah.
Sir, there are a number of cases even in Supreme Court judgment also.
Sir Jaina, I don't agree with that. Like this type of statement, I'm telling you.
Sir, I am not. Sir,
yeah, please.
Please allow me to.
Please proceed. Huh?
Sir, I know that after 90 days of becoming default, then it is declared NPA. But in many judgments, NPA date is held as default date.
Wrong. Don't agree with that, but you proceed. You proceed. Yeah.
That is not my point. Suppose on 31st March 2023, account became that default occurs on 31st March 2023. Then after 2 months, the recall notice is served. Then after 3 months, suppose in that 10 days given, and after 3 months, notice invocation notice is sent to the guarantor. So my point is that from which date that limitation against the guarantor starts.
Okay, Mr. Jaina, I will clarify this thing to you by giving an example. So let's kindly understand. Suppose there is a default. I'm taking some date in the past, like 31st December. For example, I take the date of 31st December 2009. Okay, that is the date on which there was an installment which became due, and there is a default. Okay, and suppose that was the last installment, or in other words, what we do is that loan is another important thing I will tell you. If suppose there is a term loan, for example, term loan installments are falling due every month or every quarter. So if a term loan installment is becoming due every quarter, then your default is every quarter, is at the end of every quarter, the default is there. If suppose your default, your repayment start from for example 2020 and installments are spreading till 2025, then on each and every date of default your cause of action arises. So till 2025 is the last date, for example. So from that day you will be having that limitation period. Your limitation period will start from the last date on which your last installment has fallen due. Okay, so but normally bankers, they don't wait for this entire repayment period to be over. Once 1, 2, 3, 4 installments are defaulted, they recall the loan, and then in that case the date of recalling of the loan, and in that recall notice we give them 10-15 days time period for the purpose of making payment. So when that 15 days period expires, from that day your limitation start. Okay, I come to my come to my example. So suppose there is a default, and then there is a default on 31st for example 31st, I said that 31st December 2009. Suppose recall notice was issued and time was given. Recall notice was issued because there were certain defaults. Time was given for under the recall notice till 31st December 2009, and default, the borrower does not make the payment by that day. So the limitation against the principal debtor will start from 1st January 2010. Okay, so 3 years time period is there with the creditor for proceeding against the principal borrower. Okay, and then now within this 3 years period you can invoke the guarantee. Invocation of guarantee, for invocation of guarantee you are having this 3 years time period. So invocation has to be made when debt is still alive. Okay, so limitation for guarantor will not start from 1st of January 2010. Suppose the
maybe 2013.
I'm coming. Now the creditor is entitled to invoke the guarantee at any moment after 1st January 2010, but he does not invoke. He invokes the guarantee at the expiry of 3 years, before the 1 day before the expiry of that 3 years period, because now debt against the principal debtor remains alive till 31st December 2012. 3 years will be 2010, 11 and 2012. So 31st December 2012 is the last date on which the debt will become time barred against the principal debtor. Okay, so 31st December 2012, if notice of invocation is served on the guarantor, okay, so on last date when debt was still alive, notice of invocation is served on the guarantor and the time period of 10 days is given to him. So 10 days time period will be expiring on which date? It will be, for example, 10th January 2013, it expires. So because 10 January 2013, this time period time period which is given in the under invocation notice is expiring, from that day, the limitation will start against the guarantor. Okay, so 3 years period is available to the creditor to proceed against the guarantor. Okay, I hope you have understood. If any questions on this?
Thank you, sir.
You agree with this?
Yes, sir.
Okay. So kindly understand, invocation can be made during the 3 years period. Okay, so it is not necessary that on the first day the creditor will be invoking, though he is having that option. If he wants to proceed against the guarantor first, on the first day after that recall notice period is over, on the first day he will be issuing notice to the guarantor. And then another important thing is, suppose in our example 31st December 2012, that limitation period is expiring against the principal debtor. If principal debtor on that day acknowledges the debt, then 3 years time period from that acknowledgement will be counted. So again, the time period is renewing. So then from the date of acknowledgement, 3 years time period will be counted, and then during that extended time period, you can invoke the guarantee because debt is still alive. So it is not that from the date of default by the principal debtor, the creditors can proceed against the guarantor during that 3-year period. No, if there is some further acknowledgement till the time debt is alive against the principal debtor, okay, the guarantee can be invoked, and once after invocation there is a default by the guarantor, 3 years time period is available then. So in this particular matter, Supreme Court, so this is the judgment of Deepak Bhandari versus Himachal Pradesh State Industrial Development Corporation. It was prior to the notification of IBC. Then in the instead case, Honorable Supreme Court held that the right to sue under a contract of indemnity or guarantee would principally arise when the indemnifier or the guarantor fails to pay the money claimed from it, and not from the time when the recall notice is served. Okay. If while making the demand for payment, no period is stipulated within which the payment should be made, the breach occurs or right to sue accrues when the demand is served on the guarantor. Suppose, as I said, that if suppose the guarantee deed says that 10 days time period has to be given after invocation, but if suppose guarantee deed is silent on this, so the day you issue a notice that okay, make the payment immediately. So immediately then from the date the breach occurs or right to sue accrues when the demand is served on the guarantor. So from that day, the limitation will start. Now, Ferro Alloys Corporation Limited versus Rural Electrification Corporation, which is REC. So here the question which arose before Honorable NC LAT was that whether the CRP can be initiated against CD before initiating the insolvency proceedings against the guarantors. Actually, in this particular case, two corporate guarantors were there. Okay, so question was whether you can proceed against the guarantors without initiating the CRP process against the principal debtor. So Honorable NCLAT in this particular matter, kindly see what they have said. It is not necessary to initiate CIRP against the principal borrower before initiating the insolvency process against the corporate guarantors. It is always open to the financial creditor to initiate insolvency process under Section 7 against the corporate guarantor without exercising the same against the principal borrower. Okay, so it is not necessary that you have to proceed against the corporate debtor first. And then if you have not initiated insolvency process against him, you can't proceed against the guarantor, whether it is individual guarantor or corporate guarantor. Okay, so this is the judgment of Honorable NCLAT, Ferro Alloys Corporation Limited versus REC. I think must be 2017, yes. So in 2017, this order was there, I think against the order of Honorable NCLT Calcutta, and against that order, this order of Honorable NCLT was there, and this order of Honorable NCLT was also appealed against, and the appeal was dismissed by Honorable Supreme Court. Okay, so this is the final position now, that you need not initiate CIRP against the guarantor before initiating the insolvency resolution process against the individual guarantor or the corporate guarantor. Now, another important judgment, Vishnu Kumar Agarwal versus Piramal Enterprises. Here question was that you, for the same set of claim and default, you are proceeding against the principal debtor and then you are proceeding against the guarantor. So question was that for the same default, you are proceeding against the two entities. So whether that is permissible. So Honorable NCLAT, this is also an order of Honorable NCLAT. Honorable NCLAT said that though you can file your insolvency application for initiation of insolvency process against two entities, but if one application is admitted, then other application will not be admitted. So this was the view of Honorable NCLAT, which I think is not a proper view. Subsequently, Honorable NCLAT has in another matter given a totally contrary view. Okay, so for some period of time, this was the judgment which said that for the same amount of debt and default, you can't initiate, two insolvency processes can't be initiated. Okay, can't be admitted rather. Okay, so once you can file the application, but if it is one application is admitted against, suppose guarantor, corporate guarantor, so you can't proceed against the principal debt, the admission can't take place against the principal debtor. So this was the view earlier. And though this is against this order, appeal is still pending before Honorable Supreme Court. But in the meanwhile, there is another judgment, Athena Energy Ventures Limited, which is an order of Honorable NCLAT in the matter of SBI versus Athena Energy Ventures Private Limited. So same issue arose, and Honorable NCLAT said that yes, it can be admitted also. So you can, against the guarantor, you can proceed against the principal debtor also, and both the insolvency processes can be admitted. So it is not that if you admit one, then you can't admit the other application. Okay. So this is another judgment on this particular issue. Limitation period for taking insolvency action against the personal guarantors. We have already discussed this thing. I think you must be having complete clarity about the same now. But let's see what are the judgments. So as I said, point of time from which limitation period commences against a guarantor. So in Deepak Bhandari versus Himachal Pradesh SIDC case, Honorable Supreme Court held that right to sue under a contract of indemnity or guarantee would principally arise when the guarantor fails to pay the money claimed from it, and not from the time when the recall notice is served. Then, now, law of limitation, as all of us know, that it prescribes or fixes the time period for exercising legal remedies under different statute and barring legal actions beyond that period. So limitation law of limitation or limitation period is during which you can exercise your legal remedy. If you fail to do that, then after that you are barred from taking legal action. Okay. So limitation period. Now question is that whether what is the limitation period for filing of application under IBC? If you want to initiate insolvency resolution process against a debtor, whether corporate or individual, then what is the time limit within which you should do it? So the limitation period for this purpose is prescribed under Article 137 of Limitation Act, which is a residual clause. So which does not clearly says that for filing of insolvency resolution application, the time period is 3 years. No. So this entry 137 in Schedule 2 Limitation Act. So we are having Limitation Act, all of us are aware. There is a schedule to that in which all these limitation periods have been prescribed. So 137 is the article or entry which says any other application. So 1 to 136 different kind of applications, suits and other things are there. But here it says any other application for which no period of limitation is provided elsewhere in this division, then the 3 years is the time period. When the right to apply accrues, so this 3 years time period is to start when the right to apply accrues. So in our case, in case of a guarantor, right to apply accrues when there is a default by the guarantor. So after invocation, whenever he is committing defaults, with effect from that day, 3 years time period is there. Okay. And then earlier there was a confusion as to whether Limitation Act should apply to the proceedings under IBC. Okay, so Section 238A was subsequently inserted with effect from 2018, clarifying that Limitation Act will apply to the proceedings under this one, under IBC, except where already under IBC, it is specified that some timeline is specified under IBC. So otherwise, the Limitation Act will be applying. Syndicate Bank versus V. Channa Virappa, Baleri and others. So this is a judgment of Honorable Supreme Court. Here, Honorable Supreme Court has held that limitation as to guarantor's liability depend on the terms and condition of contract, and such limitation starts running only when actually a demand for payment is made and was refused by the guarantor. The same thing. So when you make a demand, you invoke the guarantee and guarantor does not make the payment. However, such a demand should not be time barred against the principal debtor. Okay, so once suppose there is a default by the debtor, principal debtor, 3 years time period expires, and during that period you don't invoke the guarantee. So after that you can't invoke the guarantee. Okay, so in this particular matter, Honorable Supreme Court said that a demand should not be time barred against the principal debtor. If it is time barred against the principal debtor, then you can't raise a demand on the guarantor. So it should be a live claim, and cessation of operation of account cannot be treated as a refusal to pay by the principal debtor. So in that particular matter, the plea was being taken that there was a cessation of operation of account of the bank account. So that is not relevant for us. Here, the rule is as held by Honorable Supreme Court in Syndicate Bank versus V. Channa Virappa, Baleri and others, that the limitation starts when there is a default by the guarantor, and then the invocation can be made only when there is a live claim. Then a guarantor's liability depends upon the terms of his contract. If the debt had already become time barred against the principal debtor, the question of creditor demanding payment thereafter for the first time against the guarantor would not arise. So for the first time, if he had already invoked earlier, before the debt had become time barred against the principal debtor, then from that day, the limitation period will start. When the demand is made against the guarantor, if the claim is a live claim, that is a claim which is not barred against the principal debtor, limitation in respect of the guarantor will run from the date of such demand, and refusal / non-compliance. From the date of such demand and refusal / non-compliance, not from the date of demand, but from the date of refusal, where guarantor becomes liable in pursuance of a demand violently made in time, the creditor can sue the guarantor within 3 years, even if the claim against the principal debtor gets subsequently time barred. Okay, so you can claim against the guarantor, against the principal debtor has become time barred, but still, because before that, the debt became time barred against principal debtor, you invoked your guarantee, and now 3 years time period is available from that day. So debt may become time barred against the principal debtor, but because you had invoked guarantee even guarantee prior to that, you can still proceed against the guarantor. Lakshmipat Surana versus Union of India. So this is again relating to liability, acknowledgement of liability on limitation. So if during that period, if the corporate guarantor, he acknowledges the liability before it becomes time barred. So you know that acknowledgement after a debt has become time barred is of no consequence. Acknowledgement must be before a debt become time barred. Okay. So before the debt becomes time barred, if there is an acknowledgement, okay, so then the limitation will extend also against the guarantor. So not only against the principal debtor, but against the guarantor. So this is the acknowledgement of debt acts as has the effect of increasing that limitation period that is provided under Section 18 of Limitation Act. Now, question was whether Section 18 of Limitation Act will apply to the insolvency proceedings. So in this particular matter, Honorable Supreme Court said yes. So Honorable Supreme Court in the said case settled the issue of the applicability of Section 18 of the Limitation Act to applications for initiation of insolvency proceedings under the code. It was held that when a principal borrower and or the corporate guarantor acknowledges the liability, a fresh period of limitation is required to be computed from the time when the acknowledgement was so signed by the principal borrower or the corporate guarantor, provided the acknowledgement is before expiration of the prescribed period of limitation. Okay, so acknowledgement can be only when a debt has not become time barred. In relation to the liability of a guarantor, the Honorable Apex Court retreated that such liability is co-extensive with the principal borrower under Section 128. Therefore, when the principal borrower acknowledges its liability, the period of limitation for enforcing rights under such a guarantee would also stand extended, subject to the contract of guarantee. Okay. So this is Honorable Supreme Court in the matter of Lakshmipat Surana. That was in, I think, 2020. Then Vishal Jaiswal and another. So Asset Reconstruction Company, Arcil versus Vishal Jaiswal and another. Here the question was that the corporate debtor, if he is acknowledging the liability in its books of account or in its balance sheet, whether that should be treated as acknowledgement. Answer is, to this answer was given by Honorable Supreme Court. Honorable Supreme Court said yes. If suppose there is a default 5 years earlier and there is no other acknowledgement or correspondence or transaction in between, but the corporate debtor's balance sheet is reflecting that amount of liability to the creditor, then that is treated as an acknowledgement of debt. So every time this acknowledgement is made, 3 years time period will start from there. Okay. Now, question is that it is not necessary that liability is specifically disclosed in the balance sheet. So what we say is that secured debt, we don't disclose the name of a particular banker. So whether in that case also that balance sheet will be treated as acknowledgement of the debt? Answer to that is yes, provided in the books of accounts, the liability is reflected. Okay, so it is not necessary that communication has to go to the debtor, to the creditor, that this liability is there in my books of accounts. No, if
how will it be proved?
Hello,
sir, how will it be proved if it is not shown? Suppose name. First of all, in many cases, this balance sheet is not available, though it is filed with ROC. In many cases, this balance sheet are not available if it is filed in XBRL form. Number one. Number two, if it is filed and the name of the creditor is not taken, then how can we show that my outstanding is there in their balance sheet?
Okay. Okay. So now this question is there. Definitely this issue will arise as to how you will be proving that it is reflected in the balance sheet. So what you can do is you can request the court to issue directions to that party that you will be saying that yes, this is the liability which is reflected in the books of accounts or balance sheet, but the court may also ask you to show some evidence, to attach some evidence. But if you can show some evidence, if suppose you are having some evidence to show that yes, there is in the balance sheet it is there, name is reflected. Suppose for example, till 2018, for example, the debt was specifically reflected in the books of in the balance sheet. Okay, so total amount of debt is, for example, 15 crore, which is reflected as secured debt. Next year he removes your account name, but the debt is still continuing. So this type of a situation, definitely this issue will be there as to how to prove that. But if you can prove that yes, in the balance sheet or books of account, that liability is reflected. Now question is that you are an insolvency professional, for example, and a bank files or a creditor files a claim before you. And that claim for the last 3 years, 4 years, there is no communication. But in your books of account, you have seen that yes, this liability is there. Or last balance sheet, whatever balance sheet was there, though it is not mentioned clearly in the balance sheet, but if you will be having the details of all the groupings, details of all groupings and everything, from where you can see that yes, that is there. So as resolution professional, you are under an obligation that yes, there is an acknowledgement in the books of accounts. You will not simply for this reason because he is not having access to your books of account, you will not treat that as a debt which is within the limitation period. So as
sir, I am not asking. Sir, I am not asking question from resolution professional point of view. My question is from the financial creditor or operational creditor point of view. When I am appearing, when I am suing the debtor, in that case, if I say that the adjudicating authority, the honorable NCL, to get their documents, whether my name is there or not. In that case, what adjudicating authority says, it is your duty. When you are filing the application, it is your duty to give such documents. We cannot give order to the debtor to give their documents to prove your point. So you have to submit the documents. That from that point, I'm asking, sir.
So, Mr. Jaina, I told you that yes, this law is there, this legal position is there. If you can establish that a debt is there in the balance sheet, a debt is there in the books of account. If suppose you have obtained some copy of account from that company, so if that kind of statement is available, if suppose in the past you have seen that some statement of account was in many cases we say that auditors, they send the statement of account to the creditors for the purpose of taking their what we called in I think in auditing there is a term,
balance
confirmation, right? So if that kind of proof you have, so based on the same you can prove before the court that yes, that is still existing in the books of account, though problems are there, difficulties are there. Like in many cases we see that balance sheets are not prepared for the last many years. Balance sheets are not filed there with the MCA also. So in that case, you can't use it. So this law is there, which can be used provided you are having some supporting document. Now, second question is, so one is that if you can establish that yes, it exists in the books of account. Second thing is when you are there as RP. So in that case, I am telling you that you are an officer of the court also. You are a person who is appointed by the court. So in that case, if in the books of accounts some debt is reflected, so what will you do? Okay, so according to me, you should treat that as admission of debt. That maybe there may not be any communication for the last 3 years, 4 years, 5 years, but as RP you are having access to books of account. You know that it is reflected in the books of account. So will that not be treated as an acknowledgement of debt when you are not writing that off? So according to me, that should be reflected, that should be treated as acknowledgement of debt. Okay, so this is the legal position with respect to acknowledgement of debt. If a debt is reflected in the books of accounts and also in the balance sheet, and if not also in the balance sheet, what I'm saying is that in balance sheet you don't know, but if in your books of account it can be proved that in your books of account there is a debt which is reflected, that should be treated as a, if you can prove that, then that should be treated as an acknowledgement of debt. Okay. Now, right of subrogation to the guarantor. Right of subrogation. All of us know it's also a very complicated kind of things. I think all of us must be having various questions relating to the same. So first is that when a guarantor makes the payment to the creditor, then he steps into the shoes of the creditor. Then he becomes entitled to recover that amount from the corporate debtor or debtor, as the case may be. Okay, but there is a, mostly we are having that clause in the guarantee deeds that we will not be competing. We will not, when our bankers, they get these guarantee deeds executed, so they provide that we will not be competing with the bank. If suppose bank is having a debt of rupees 100 crore, okay, and I have given a X, Mr. X has given a guarantee, and the bank proceeds against the guarantor and is able to recover 40 crore, for example. So then in that case, whether the guarantor can proceed against the debtor for that amount of rupees 40 crore. Now banker's debt reduces to 60 crore. Now question is whether the creditor's claim will be reduced to 60 and guarantor will be filing a claim for rupees 40 crore. So my answer to that is no. Reason is that normally the deeds, guarantee deeds, they provide that you will not be in such a kind of situation. Guarantor will not compete with the creditor. Now problem is that money has been paid by the guarantor. So money is not paid by the corporate debtor. Whether the creditor should reduce the debt to 60 crore, whether he should not file his claim for total 100 crore only. Because if he files a claim for 60 crore and all secured creditors, they are getting, for example, 60% of their dues, then the creditor will be getting how much? 36 crore. But if he retains the claim at 100 crore, then he becomes entitled to what? 60 crore. 40 he has recovered already. So is it mandatory for him to reduce his claim to 40 crore? My answer to that is no. He should not. He should retain his claim at the same amount of 100 crore. And if suppose, so now when he is filing, he is there as a creditor for an amount of rupees 100 crore. And if there is any recovery over and above that total amount of 100 crore, suppose 40 crore he has recovered from the guarantor and from the corporate debtor he is able to recover 80 crore, then this 20 crore excess should be given to the guarantor. Because actually he is also having a right of subrogation. Okay, if suppose there is a debt of rupees 100 crore and the guarantor he pays entire 100 crore, then creditor is out. Then in that case, guarantor becomes the secured creditor. He steps into the shoes of the secured creditor. But if he is not able to, he does not make the complete payment. If he does not make the complete payment, then in that case, because of the clause in the guarantee deed, he can't compete with the creditors, with the secured creditors, and then he will not be filing his claim. Okay, now can be another situation where, now let's consider the other situation where the creditor, he recovers the money from the guarantors, from the corporate debtor. 100 crore is the claim. He recovers 60 crore from the corporate debtors. Now his debt is actually reduced to 40 crore. So he will not file a claim for an amount of rupees 100 crore against the guarantor, because against the guarantor he can proceed only for the defaulted amount. So if the insolvency process of guarantor is initiated, he will be filing a claim of rupees 40 crore. But if both the processes are going on simultaneously, he will be filing his claim for an amount of rupees 100 crore in both the processes, before creditor also, before debtor also, in the CRP of debtor also, and in the insolvency process of guarantor also, he will be making his complete claim. But he can't recover more than that 100 crore. Okay. So if he is able to recover more than that, then to that extent, because right of subrogation is there with the guarantor, so excess he has to give to the guarantor, but from the debtor, or the total amount of recovery which he makes from the debtor as well as from the guarantor cannot exceed the total outstanding amount. So this is right of subrogation. And from where this right is coming? This right is coming from section 140 of Indian Contract Act, 140 of Indian Contract Act, right of surety on payment of performance, where a guaranteed debt has become due, or default of the principal debtor to perform a guaranteed duty has taken place. The surety upon payment or performance of all that he is liable for is invested with all the rights which the creditor had against the principal debtor. So if creditor is holding some security, so then the debtor becomes entitled to that security. Okay, so guarantor becomes a secured creditor of the debtor to that extent. Okay, so this is section 140. Now, contents and structure of individual insolvency, rather not individual insolvency, it is bankruptcy process, not individual insolvency. You have already taken, I think morning there was a session on individual insolvency. But before that, let's see what are the goals, why this individual insolvency and bankruptcy process should be there, and what are the goals of these processes. So I asked you one question in the beginning. We were discussing as to why a discharge order should be released in favor of the debtor, why he should be given a discharge. So I think answer can be there here in the goals of the process for individual insolvency, and these goals are specified. These goals I have taken from the BLRC report, Bankruptcy Law Reform Committee report. So these goals are the process, individual insolvency as well as bankruptcy process we are talking about here, providing a fair and orderly process for dealing with the financial affairs of individual insolvent individuals. So meaning of the same is that it is not that the person has become insolvent, so we are entitled to sell his assets in any manner we want. If he is having some assets, we should try that the process should be run in a fair and orderly manner. The attempt should be to maximize the recovery. So if we are selling the assets, we must ensure that maximum amount of sale proceeds are there. So he is entitled, individual who is insolvent, he is entitled for a fair and orderly process, because reason for the same is that if any surplus is there in the process, he is entitled for the same. So if suppose he is having a building worth rupees 100 crore, or he is having a factory worth rupees 100 crore, and his dues are only 40 crore. Okay, so because liquidity problem is there, and our definition of insolvency is based on cash flow, based on default. So it is not based on net worth. So his assets are 100 crore, liabilities are 40 crore. Even then, he's an insolvent person as per our definition. Okay, so in that case, there can be a surplus also. He is not able to sell, because most of us know that selling a industrial asset is difficult. It's not an easy process, or it is not easily sellable. Okay, so in that case, it may take time, but it may happen that against asset worth rupees 100 crore, you may be able to sell for 60 crore, and his liabilities are only 40 crore. So he is entitled to that surplus of 20 crore. Okay, so we must provide a fair and orderly process for dealing with the financial affairs of insolvent individual. Then providing effective relief or release from the financial liabilities and obligations of the insolvent. Okay, so providing effective relief or release from the financial liabilities and obligations of the insolvent. So this is also one of the important objective, that the individual insolvent, he should be, or insolvent individual, he should be given a release or discharge order. So it is not that if suppose there is an individual, he sets up a new business and that business fails. So that does not mean that in future he can never be allowed to do any business, because otherwise we will kill the entrepreneurship. Okay, so the law is, or law should be, that if you have faced a failure in your business, then in that case the insolvency process and bankruptcy process should take place. And then under bankruptcy process, what we do is that bankruptcy trustee, he will be taking over all the assets, except certain exceptions are there, of the bankrupt. All assets are taken away from him. Those assets are disposed of, and then the sale proceeds are distributed amongst the creditor as per section 170. As per section 178, which is similar to our section 53, except some changes there. So as per section 178, the asset should be distributed. The sale proceeds should be distributed. Then after that, what is to be done? Now he's not left with any asset. Okay, so now whether we should allow him to restart his life afresh, whether he should start his life afresh, or we should jail him. So our policy makers, they have decided that no, if a business failure does not mean that he will be barred from doing any business for the entire life. If he has suppose committed a fraud, then that is another thing. He will face the consequences of that criminal activity. Okay, but this discharge is not from criminal activities. This discharge is from civil liabilities only. Okay, so providing effective relief or release from the financial liabilities and obligations of the insolvent, so that the person of owner of that of failed business, he can start his life afresh. He can start doing business again. Okay, though difficulties will definitely be there. No bank will be giving him further loan for some period of time. Okay, creditor may not supply him with the goods and services and all. So life will be difficult for him. But still, our law provides that yes, he should be given another chance. Then providing mechanisms that enable both debtor and creditor to participate with the least possible delay. So now insolvency process or bankruptcy process, actually, both the debtors and creditor, they should participate, but it should not result in any delay. Okay, participation of both is necessary because both of them are stakeholders. Creditors, they are entitled to the proceeds from the sale, and debtor, he wants to maximize his recovery. He wants to maximize the realization of his assets. Okay, so there should be a mechanism where debtor as well as creditor both should participate in the process, providing the correct ex ante incentives so that individuals are not able to unfairly strategize during the process of bankruptcy. So these incentives should be there. Incentives are like the debtor, he knows that if he participates or he cooperates with this process with the bankruptcy trustee, he will be given a discharge order. He can start his life afresh. Okay, and so this kind of incentive is there in the process. Then further, there are certain assets which can't be taken away from him. Okay, so that incentive is also there to him. So he knows that if he does not cooperate, then he can suffer the consequences. So he must have some incentive. So one is that he will be having other consequences. He can be penalized, but at the same, that is also a kind of incentive that if he cooperates, then he will not be penalized. or other thing is that he will still be having some assets with which he can restart his life, then he will be getting a discharge order and all. Okay, so these are the four goals, important goals of the process for individual insolvency and bankruptcy. Okay, now ingredients of an efficient insolvency and bankruptcy regime, I think we should skip that. Consequences of inefficient rescue regime in India, that also can be. Now let's go to notification and applicability. Notification and applicability. The Insolvency and Bankruptcy Code classifies individuals into three classes. So presently, as you are aware, that now we are having, originally this was not the case, but now we are having classification of individuals into three classes. One, personal guarantors to corporate debtors. Two, partnership firms and proprietorship firms. So here all those individuals, partnership firms and individuals who are doing some business. And third is other individuals who are not doing any business. Okay, so these three classes are there of individuals. And now the provisions with respect to first class only, personal guarantors to corporate debtors, have only been notified. Other classes are not yet notified. We don't know how much more time it will be taking, but you know that the with respect to second and third class, the jurisdiction will be with debt recovery tribunals. Okay, so that infrastructure, I think a lot of efforts are required to be done there. So first class is having the jurisdiction is only with NCLT, which is already functioning properly. So these provisions have only been notified relating to personal guarantors to corporate debtor. So provision of Part 3 of the code have only been brought into effect insofar as they are applicable to a personal guarantor to CD. Okay. Ministry of Corporate Affairs. So this notification came on 15/11/2019, and with effect from 1st December 2019, these provisions were brought into effect. Though you are aware that we have seen different challenges to this law. Earlier also there was a challenge made to this law, to this notification. So this notification was earlier challenged, but Honorable Supreme Court said that no, everything is constitutional, nothing bad about this notification is there. Okay, so whatever objections were raised with respect to this notification, they were rejected by Honorable Supreme Court. Okay, and then again we are having, you are aware that we are having again one challenge is there, which is pending before Honorable Supreme Court, because of which we are not able to proceed with these proceedings for insolvency resolution and bankruptcy. So including clause 2E of IBC code dealing with personal guarantors to corporate debtor and part 3 of IBC, except fresh start process, have been notified. So first challenge to these provisions, actually this challenge was to notification dated 15/11/2019. So there was a challenge which was made before Honorable Supreme Court and before different high courts also, which were finally settled by Honorable Supreme Court. And a number of industrialists, a number of businessmen who were guarantors to the corporate debtors, and it included they included the promoters of Dirty 12 matters. Okay, so all of them and a number of other promoters who were guarantors, they challenged the notification dated 15/11/2019. And Honorable Supreme Court, all of us are aware of this judgment of Lalit Kumar Jain versus Union of India. So these issues were settled by Honorable Supreme Court through this judgment. And what were the issues, or what was the major issue in this? Major issue was that they said, if suppose there is a corporate debtor who goes into insolvency and there is a resolution plan approved with respect to that corporate debtor. So for example, if the dues of a corporate debtor are 1,000 crore, and then, or we take the example of 100 crore. Suppose dues of the corporate debtor are 100 crore. And then there is a resolution plan that is approved. in favor of a third party, and that third party says that I will be paying 60 crore to the financial creditors in the resolution plan. Okay. So now question which was raised by, and this resolution plan is approved by the COC consisting of these creditors. Okay. And then Honorable NCLT also approves this particular resolution plan. Now, the promoters who were the guarantors, they said that you have accepted, the creditors or lenders, they have accepted 60 crore in full and final settlement of their dues. So the remaining debt of rupees 40 crore extinguishes. There is no debt. If you are accepting 60 crore from the debtor, corporate debtor, who is the principal debtor also. You gave the money to that debtor only. Now you have settled with that debtor. So now you cannot demand this money because there is no debt, remaining debt, which is still existing. So against the debtor, 60 crore is the amount for which the entire debt is settled and there is no more debt left. So they said that there can't be any proceedings against these guarantors, against these personal guarantors. Okay, so they said that this is unconstitutional. So Honorable Supreme Court in that case said that this process is an involuntary process. So here it is not that there is a settlement between the corporate debtor and the creditor in a process, not through a legal process, or it is not a voluntary settlement. If suppose you are out of the insolvency process, if you are not there in the insolvency process or CIRP or liquidation, in that case, if debtor settles with the creditors, debtor settles with the creditors and creditor accepts the settlement, in that case, guarantor will be released. But here it's an insolvency process. In insolvency process, you can get whatever maximum based on the transparent process. So it is not your full recovery. You are recovering only from the assets of the debtors, or for the assets of the debtor, you are getting some money. But that does not mean the guarantors, they have guaranteed. Why the creditor has taken the guarantee? Because creditor feels that in case this company goes into insolvency, they will not be able to recover full dues. So for that purpose only they have taken the guarantee. So in case they are not able to recover their full dues, in case of insolvency of these companies, then they can proceed against the guarantor. So this was the view of Honorable Supreme Court. Honorable Supreme Court said, upheld the constitutional validity of notification dated 15/11/2019. Honorable Apex Court further held that sanction of a resolution plan and finality imparted to it by Section 31 does not per se operate as a discharge of the guarantor's liability. So approval of a resolution plan does not operate as a discharge of the guarantor's liability. Okay, so this was the view of Honorable Supreme Court. Justification is also given for the same. Court referred to Maharashtra State Electricity Board judgment along with other judgments and clarified that the approval of a resolution plan does not ipso facto discharge a personal guarantor of her or his liabilities under the contract of guarantee. Then, as held by this court, the release or discharge of a principal borrower from the debt owed by it to its creditor by an involuntary process, that is by operation of law or due to liquidation or insolvency proceedings, does not absolve the surety oblique guarantor of his or her liability which arises out of an independent contract. So Honorable Supreme Court said that it is not a voluntary settlement by the creditors. It is not that they are under some settlement outside this process, they are accepting some lesser amount. No. So the involuntary process, that is by operation of law due to liquidation or insolvency process, does not absolve the surety guarantor of his or her liability which arises out of an independent contract. It was also held that approval of a resolution plan relating to a CD does not operate so as to discharge the liabilities of personal guarantors. Okay, so this was and there were other issues also which were raised by these people, but Honorable Supreme Court said no. The guarantors can be proceeded against. So I think it is 3 o'clock now. Let's break for 10 minutes and then come back.
Yes, sir.
Okay. So after 10 minutes, we meet again, huh?
Sure, sir.
Okay, thanks. Shall we start now?
Sir, can we start?
Yes. Yes, Surbi.
Yes, yes, sir. Yes.
Yes, yes, yes.
Okay. Applicability of Part 3 of IBC, Chapter 1, Section 78. All of us are aware that the amount of default should be more than ₹1,000 rupees. Then only insolvency resolution process can be initiated against an individual. And this amount can be increased up to 1 lakh of rupees by the central government. Then, so now we are going through the provisions of law relating to these processes, and I'm covering the bankruptcy process, but I think certain definitions are important, which we'll go through. Jurisdiction, So you are aware that earlier the issue was who is having the jurisdiction with respect to these personal guarantors to a corporate debtor. So different views were there. Some were saying that if already insolvency resolution process or liquidation process is pending before adjudicating authority, before NCLT, then in that case, jurisdiction with respect to individual guarantors will be with the NCLT. Otherwise, it will be with DRT. Okay, so pendency of any of these processes. So it was said that it should be there. Only then jurisdiction will be with NCLT. However, now these things have been clarified. And now it is very clear that the jurisdiction is with respect to personal guarantors to a corporate debtor, jurisdiction is only with the National Company Law Tribunal. With respect to two other classes, the jurisdiction will be with the Debt Recovery Tribunal. Provision for the same has not yet been notified. And in all other cases, that is where the individual is not a guarantor. Okay, so in that case, and with respect to the partnership firms also, other than LLPs, the jurisdiction will be with Debt Recovery Tribunal. So DRTs will be the adjudicating authorities in those cases. Then I think we can skip this one. NCLT or DRT, this issue is, so earlier there was a confusion as to who has the jurisdiction over the insolvency and bankruptcy matter of individual guarantors to CD, NCLT or DRT. Interpretation of section 61, I think we can skip it. We should not waste our time further, except that this was the judgment where Honorable Supreme Court clarified. So this was Mahindra Kumar Jajodia versus SBI, Sam Branch. Honorable Supreme Court, through its initial order dated 21st March 2022, stayed the operation of the NCLAT order. Later, through an order dated 6th May 2022, it outrightly rejected the appeals and affirmed the NCLAT order, stating that they do not see any cogent reason to entertain the appeal and that the judgment imputed does not warrant any interference. So Honorable Supreme Court in this matter upheld that with respect to individual guarantors to the corporate debtors, the jurisdiction is only with the National Company Law Tribunal, not with DRTs. Whether there is any pendency of liquidation or insolvency resolution process or not. Okay, in all the cases. So even if, suppose for example, there is a guarantor to the corporate debtor and the creditors, they have not initiated action against the corporate debtor, they have not initiated CIRP against the corporate debtor, they can still proceed against the individual guarantor, they can still proceed against any corporate guarantor also. So it is not necessary that first you have to initiate action against the corporate debtor and then only you can proceed against the guarantor. Jump. Initiation of IRP against personal guarantors to a corporate debtor are governed by the following principles. A creditor can initiate IRP against personal guarantors to a corporate debtor prior, during, and after the completion of CIRP against the corporate debtor. So whether or not the action is initiated against CD, you can initiate. When there is a pendency of CIRP or liquidation, even then you can initiate. Or if the CIRP and liquidation is over, even then you can proceed against the personal guarantors to a CD. IRP against the, now there is another question. Another important question here is that if there is a guarantor to a corporate debtor, okay, and there are operational creditor or any other creditor, any other financial creditor who is not holding any guarantee, okay, but he knows, but they know, both of them, they know that this particular individual has given guarantee to a bank in respect of the debts of a corporate or corporate debtor. So whether these creditors, whether OC or financial creditor, they can initiate any action, any CIRP, whether they can initiate the action against the guarantor of the CD. Okay, so again, I repeat, there is an individual who is a guarantor to the debt of a corporate debtor given to some bankers. So this guarantor is having some operational creditor and some other financial creditors who are not having any, they are not holding any guarantee or anything. Okay, whether those creditors can initiate insolvency resolution process against this individual, because provisions relating to guarantors to a corporate debtor only have been notified. But whether these creditors can initiate, so these are not the guarantee holder. Any view on this? No? There is no view on this? Okay. So according to me, the provisions which are notified are relating to the individuals who are guarantors to the corporate debtors. Okay. So now against those individuals also, OCs can initiate the insolvency resolution process. Financial creditors can also, including those who are holding guarantees. So according to me, anyone, law does not say that these provisions are notified only when the creditors who are holding the guarantee of that individual, they can only initiate insolvency resolution process. So nowhere it is provided. Yes.
But sir, whether they can have that locus?
No, locus is definitely there. Locus is any creditor under these provisions. Now these provisions are notified with respect to those individuals who are guarantors to a corporate debtor. So definitely all these individuals are guarantors to a corporate debtor's dues to a financial creditor. Now one OC wants to initiate an action. So what he has to do? Whether he will wait for any of the secured creditor to initiate or the guarantee holder to initiate action? Answer is no, because nowhere it is provided. The law says that these provisions are notified with respect to, the notification says that these provisions are notified with respect to those individuals who are guarantors. So these individuals, they can be proceeded against by the operational creditors, though the word operational creditor is not used under law, under this part of the law, but any creditor, any unsecured creditor can also. So it is not that only those who are holding guarantees or first they have to take action and then only any other creditor can do that. So if any supplier is there or any service provider is there, so according to me, he can also initiate.
But sir, if let's say even if some third party is suppose an OC is filing against these guarantors, whether at the end of it he will be beneficial in any ways? Because
no, Charuji, that is not the question. That is not the question. He may or may not be benefited, or he is taking this action so that the debtor, he comes forward for settlement. But question is whether legally this type of action can be taken. That is the question.
Okay.
So according to me, if we see the notification, it nowhere says that only the financial creditor or creditor who is holding the guarantee, he can only initiate. Okay.
Yes.
Next, framework of IBC adjudicating authority. So insolvency and bankruptcy code, we are having corporate debtors, okay, including LLPs. So their insolvency resolution and liquidation, these two processes are there. And jurisdiction is with National Company Law Tribunal, who is the adjudicating authority. Appeal against that goes to appellate authority. And then Then after that, second appeal goes to Honorable Supreme Court. And with respect to individuals, we are having three classes. One, individuals are of two kinds, individual and partnership firms. Individuals are of two kinds. One, who are those who are having personal, who are the personal guarantors, and others who are having proprietary business, or third class is individuals without any business. So the first class, which is personal guarantors to corporate debtor, with respect to them, the individual insolvency resolution and bankruptcy process, the jurisdiction is with NCLT. With respect to all other classes, partnership firms, proprietary business, individuals without business, the jurisdiction is with Debt Recovery Tribunal. And Debt Recovery Tribunal, against the order of Honorable Debt Recovery Tribunal, the first appeal will go to Debt Recovery Appellate Tribunal, and second appeal will be going to Honorable Supreme Court of India. Okay, so this is the our framework of IBC with respect to adjudicating authority and appellate authorities. Circular dated 2nd February 2021 has notified Rule 9 of the IBC, application to adjudicating authority for insolvency resolution process for personal guarantors rules. It mandates an application to provide a copy of the application. So if you are filing an application under section 94 or 95, then copy of the application must be given to IBBI also for its record. Differences between CIRP and individual insolvency processes, I think you must have, in the morning session, you must have been apprised about the same. But again, very quickly, in CIRP, we have classification of creditors as financial and operational. Under individual insolvency, we are not having that classification. Under CIRP, we are not having any interim moratorium, but under individual insolvency, interim moratorium is available, and that is available from the date of filing of application for initiation of insolvency resolution process. Role of RP in case of CIRP, from the date of admission of application, only RP is appointed. However, in individual insolvency, from the time of scrutiny of application for initiation, so even before the admission, because under section 99, that report is to be given by the RP. Okay, so his role starts from even before the admission of application. Possession of assets under CIRP, possession goes into the hands of RP on admission, but under individual processes, the possession goes to the bankruptcy trustee only on initiation of bankruptcy process, not before that. Individual insolvency resolution process, the possession of assets remain with the debtor only. Consequences of rejection of plan. So suppose there is no resolution plan which is approved, or if a resolution the plan has been filed with adjudicating authority, the adjudicating authority rejects, or the plan fails. In that case, the company must go for compulsory liquidation. However, in the case of individuals, if insolvency resolution process fails, then or a repayment plan is approved, which is not, and as per which payment is not fully made, then in that case, the creditor whose dues remain unpaid, he is entitled to file an application for bankruptcy. So it is not mandatory, or it is not automatic, like compulsory liquidation process. So it is only when that creditor is allowed to file an application. Provisions of IBC relating to bankruptcy of individual guarantors to CD. So some important definitions are there. First of all, section 79, clause 14. So there are certain excluded assets. So these assets are not covered. These are not taken away from the bankrupt. Okay, so the guarantor or bankrupt, he is allowed to retain these assets. So as I told you that in case of individual bankruptcy process, what happens is that bankruptcy trustee, he takes away all the assets and then he disposes them off and distributes the sale proceeds. But he can't take away. He takes away all the assets except these excluded assets. So these assets are, so this is a policy matter, or it is the policy of our state that certain assets will be allowed to be left with the bankrupt so that he can start his life afresh. So failure of business doesn't mean that he loses the right to live. So I think these assets have been will be left with him so that he can live his life and he can start his life afresh. So these excluded assets are, so these assets can't be taken away in the case of bankruptcy. Unencumbered. So first of all, you see the first word of all these paragraphs is and all these clauses are, the clauses is unencumbered. So unencumbered means that if suppose there is some asset which is otherwise excluded, but he has created a charge over the same, like single dwelling unit. If he is of certain value, is allowed to be excluded under bankruptcy. But if he has created a charge over the same, then it can't be excluded. Then the secured creditor, he is entitled to take possession, to deal with the same under bankruptcy process. So all these clauses, the first word is unencumbered. Okay, so unencumbered, so there is a prerequisite. If there is any encumbrance, then these assets will not be treated as excluded assets. Okay, unencumbered tools, books, vehicles, and other equipment as are necessary to the debtor or bankrupt for his personal use or the purpose of his employment, business, or vocation, so that he can continue to do some make some earning for his living. Okay, so some tools, books. So it is not that very valuable assets will be left with him. It is not some Mercedes will be left with him. No, all these books which are necessary to the debtor or bankrupt for his personal use, necessary for his personal use is important, or for the purpose of his employment, business, or vocation. So they will be excluded asset. Then unencumbered furniture, household equipments, and provisions as are necessary for satisfying the basic domestic need of the bankrupt and his immediate family. So it is not that you will take away his furniture, household equipment, and everything. So all those things which are there for satisfying the basic domestic needs. But if there are certain very valuable paintings and all, so those will be taken away. Okay, so basic domestic needs, for satisfying the basic domestic needs, if some furniture, household equipment, etc. is there, then, and it should be unencumbered, then that cannot be taken away. Unencumbered personal ornaments of such value as may be prescribed of the debtor or his immediate family, which cannot be parted with in accordance with religious usage. So what are those assets which can't be parted with in accordance? So I think best example can be Mangal Sutra. Okay, so as may be prescribed, personal ornaments of such value as may be prescribed. So it is not that if some Mangal Sutra is there, the value of which is I think a few lakhs of rupees or more than that. So then in that case, there is a further stipulation that of such value as may be prescribed. So rules they prescribe that this value of the personal ornament should not be more than 1 lakh of rupees. Okay, so if there is a Mangal Sutra, the value of which is 5 lakh of rupees, so whether that will be included here, answer is no. Okay, and there also there is I think there is no clarity about that. If suppose there is a personal ornament which falls within the ambit of this, the value of which is 5 lakh. So whether that will be excluded from here, or what we can do is that we can give him 1 lakh of rupees and take away his ornament of rupees 5 lakh. So there is no clarity. I think according to me, it means that if the value of that ornament is more than 1 lakh, then that will not be treated as excluded asset. So it is not that in that case you will give him 1 lakh of rupees, but there has to be a clarification with respect to this. So any unencumbered personal ornaments of such value as may be prescribed, so value prescription is up to 1 lakh of rupees of the debtor or his immediate family. So, but if it is the insolvency process or bankruptcy process of the individual, if some self-acquired property of his wife is there, or any other family member is there, or the asset which is not owned by, so assets which are owned by the debtor, they only can be taken away in case of bankruptcy. So it is not that family members, their jewelry will be taken away unless that is owned by him. If some jewelry is there which belongs to this debtor, he has given it to his wife, so that jewelry will be taken away, except this is an exception to the same. Personal ornament of up to rupees 1 lakh, which is of the debtor or his immediate family, which cannot be parted with in accordance with the religious uses. Okay, so the family members' assets otherwise cannot be taken away, provided they are owned by them. If these are the assets which are owned by the debtor, he has given it to his family members, so those can be taken away. However, there is this exception that personal ornaments of up to rupees 1 lakh, provided they can't be parted with in accordance with religious uses. Then any unencumbered life insurance policy or pension plan taken in the name of debtor or his immediate family. So the debtor, if he has taken some life insurance policy or pension plan, okay, and which is against which there is no loan taken, so it is unencumbered, then in that case these life insurance policy or pension plan, they can't be taken away. Whatever money he will be getting out of these two, that will belong to the guarantor only. That can't be taken away under bankruptcy process. An unencumbered single dwelling unit owned by the debtor of such value as may be prescribed. Single dwelling unit and unencumbered. So most of us are having that misconception. We feel that if he is staying in a house, single house, the value of which may be anything, so that can't be taken away. So that is wrong. So of such value as may be prescribed. So this value has been prescribed under rules. And the value is if that residential house or dwelling unit is situated in a village, then in that case, its value can't be more than 10 lakh of rupees. If it is situated in a city, okay, in an urban area, then the value should not exceed more than 20 lakh. Okay. So if you are having a house of rupees, the debtor is having a house of rupees 5 crore. So that will not fall within this particular clause. Or that clause, that dwelling unit, if it is value is less than that prescribed limit. But if it is encumbered, then in that case also it will not fall within this exception. So an encumbered single dwelling unit owned by the debtor of such value as may be prescribed. These are the rules. So these rules, you are aware that these were notified in 2019, application to adjudicating authority for insolvency resolution process for personal guarantors to CD. Now, Rule 5 of the said rules, it says, for the purposes of subsection 14 of section 79, the value of unencumbered personal ornaments under clause C of the said subsection shall not exceed 1 lakh of rupees. So that means personal ornaments of the value of the same should not exceed 1 lakh of rupees. If it exceeds, then it will be out of that particular clause. Then the value of unencumbered single dwelling unit owned by the debtor under clause E of the said subsection shall not exceed In the case of dwelling unit in the urban area, 20 lakh of rupees. In the case of dwelling unit in a rural area, 10 lakh of rupees. Okay, so this is the prescription under the rules. So it should be less than this particular value. Then there are excluded debts. So excluded assets are those which can't be taken away in the case of bankruptcy process. Now we have excluded debts. So excluded debts are those debts, actually, if a discharge order is made, if a discharge, you know that discharge order is made under section 138. So if a discharge order is made at the end of this process by honorable adjudicating authority, that discharge order says that you are discharged all of your debts, a discharge of all your debts. But that discharge order will not apply to these excluded debts. Okay, so the discharge order under section 138 will not apply to excluded debts. And another important thing is, if there is a default in making payment of excluded debts, then you can't initiate insolvency resolution process or the bankruptcy process. If you want to initiate that 1,000 rupees a minimum amount that is prescribed, if there is a default in respect of excluded debts, then you can't initiate this process. Okay, so for two purposes, these excluded debts are important. One, that you can't initiate insolvency resolution process for default in excluded debt. Secondly, discharge order does not affect these debts. The bankrupt will still be liable for making payment of these debts, even though he has got a discharge order under section 138. Okay, so now see, liability to pay fine imposed by a court or tribunal. So excluded debts we are talking about, liability to pay fine imposed by a court or tribunal. So if a court or tribunal has imposed some fine and you are under bankruptcy process and you get a discharge order, you will not be discharged from paying this liability. Then liability to pay damages for negligence, nuisance, or breach of a statutory, contractual, or other legal obligation. So here also, so according to me, this second clause should not be here. It should not be included in these excluded debts. A reason for the same is, if you see the other liabilities, like liability to pay fine imposed by a court or tribunal. Okay, so we don't want, if somebody has violated law, if somebody has violated the law where fine has to be imposed, or fine can be imposed, or fine is imposed. So we say that no, you must pay that. Similarly, liability to pay maintenance to any person under any law for the time being in force. Suppose court says that you have to pay maintenance to your wife, which is separated from you, or divorced, or your children. Okay, so if that obligation is there, so then that should not be covered. That is an excluded debt. Okay, so even if you are discharged, but you are not discharged for your obligation to maintain your wife or your children. Okay, so this is another exception, another example of excluded debt. Third is liability in relation to a student loan. Okay, so this is also a reason for the same is that a student, suppose a student takes a loan, a student loan. Okay, and then after he qualifies his exam, after he takes the degree and comes back. So first of all, what he do is that he will be filing a bankruptcy process with respect to this loan. After he gets a discharge order, then after that he will start his life. So I think the purpose seems to be that a student loan has been taken by an individual. And if suppose he is committing a default, or another reason can be that student, he has taken a student loan, he has completed his study, and after that, when he has come back, there is a default with respect to this student loan. So this process should not be initiated against him. He has not even started his life. So this process should not be initiated against him for this. Then any other debt or as may be prescribed. So these are the examples of excluded debt. liability to pay damages for negligence, nuisance, or breach of a statutory, contractual, or other legal obligation. Here, other things are okay, except contractual obligation. Suppose you have taken a contract for construction of a bridge or a residence or a building. Okay, you are a builder. You have taken a contract for construction of building, and then after that, for some reason, you are not able to fulfill that contractual obligation, and there is a damages claim for damages. Okay, so whether that should survive this process, I think that is a debt similar to any other debt. If he has supplied, one is that he has been supplied, some subcontractor has supplied him some material. Okay, he is not liable to make payment if he gets a discharge order. He is not liable to make payment of that dues of the supplier. But because of this contractual damages, etc., I don't think that it is on a different footing than any other debt of the contractor. Okay, so I think liability to pay damages for negligence is okay. Nuisance or breach of a statutory or other legal obligation can be one thing. But contractual obligations, if any damages are there, I think that should not be included here.
Sir, I agree with you. Where is the money to pay that, sir, when I'm already a bankrupt?
Correct. No, what they say is that if suppose you have caused harm to your society.
That's okay. That's okay.
No,
that's
but uska reason is, Mr. Bhaskar, they say that imposition fine to be imposed by a court or tribunal. They say that after that you will be starting your life afresh. So you will be paying it afterwards also. It is not that you will not do anything after that. So they say that these liabilities should survive. So you should not take advantage of this bankruptcy process in order to get rid of these liabilities. Okay, all other liabilities will be covered, but they say that the maintenance, payment of maintenance to your family, your ex-wife. So they say that it will have to be. But if he is not having money, he's not having money. He will not be able to pay. But if he starts earning, if suppose after that he starts earning money and he's having money, then in that case he will have to. Suppose he starts doing some job and he is getting some salary. So he should not say that I'm having this discharge order, so I'm relieved of this obligation. I think that seems to be the purpose here.
Right.
Okay. So these are excluded debts. Then these provisions have come into force with effect from 1st December 2019. The definition of guarantor, which is given in rule. Okay. So we are talking about these rules now. Insolvency and bankruptcy and application to adjudicating authority for insolvency resolution process for personal guarantor to CD. Rules 2019. This particular definition is important here. So for that purpose, I'm quoting these rules. Guarantor. Guarantor means a debtor who is a personal guarantor to a corporate debtor, and in respect of whom guarantee has been invoked by the creditor and remains unpaid in full or part. So important part is that guarantee invocation must take place, then only you can initiate this one. Matlab guarantee, you can file an application only when you have actually invoked the guarantee. If you have not done that, then you will not fall within the definition of a guarantor. So guarantor means a debtor who is a personal guarantor to a corporate debtor. That is okay. But they say that after that, in respect of whom a guarantee has been invoked by the creditor, because you become liable only when guarantee is invoked and remains unpaid in full or part. Invocation, after invocation, if you have made the payment of complete dues, whatever were claimed by the creditor, then insolvency resolution process can't be initiated against you by any other creditor or anyone. But there should be some liability which should remain unpaid, guarantee invocation, and some amount are remaining unpaid out of it. So that is the definition of a guarantor under these rules. Invocation of guarantee is a prerequisite. And what is invocation of a guarantee? I think we discussed that earlier. Invocation means demanding by the creditor of the dues due from principal debtor. So dues which have become due, if they have not become due from the principal debtor, then there is no default. So the dues should have become due from the principal debtor on his principal debtor's default in making payment from the guarantor, demand from the guarantor pursuant to the guarantee deed. So if there is a debtor who has committed a default, and then after that you are demanding those dues from the guarantor pursuant to the guarantee deed, so that is called invocation of guarantee. So when you are issuing a demand notice against the guarantor, that is invocation of guarantee. In order to fall within the definition of guarantors as provided in the rules, guarantee must be invoked by the creditors and some of the debt amount must remain outstanding. Axis Trustee Services Limited versus Bridgebhushan Singhal and another. So here, Honorable High Court has decided this matter. Honorable High Court has held, I don't know which High Court, I think it is not mentioned here. Honorable High Court held that the effect of interim moratorium is only in respect of the debts of a particular debtor, and by no stretch of imagination can it be said to include other independent guarantors in respect of the same debt of a CD. So if you have initiated insolvency resolution, you file an application against one of the guarantors. Suppose total 3, 4, 5 guarantors are there. You have filed application for initiation of insolvency resolution process against one of the 5 guarantors. Then the interim moratorium will apply to this particular guarantor only, not to other 4. Okay, so this was the order of Honorable High Court in this matter. Application for now the process. So now you know that up to section 120, from 94 to 120, and before that we are having fresh start process and the definitions and all. So up to 120, the insolvency resolution process, provisions relating to insolvency resolution process are there. And with effect from section 121, the provisions relating to bankruptcy process of individuals. So those provisions are contained. And these provisions, they go up to section 179. So 121 to 179, we are having provisions relating to bankruptcy of individuals. Okay, so I think very quickly we can go through them. If there is anything which we should discuss, we will discuss about that. And you are already aware of these provisions. So very quickly, let's go through. Application under section 121 can be filed as per section 121. Application for initiation of bankruptcy can be filed by either the creditor or the debtor, and creditor can file it jointly with other creditors also, and in the following circumstances. So these are the circumstances when the application for bankruptcy can be initiated against it.
Sir, by debtor means who is the debtor over here?
Debtor is that guarantor, the personal guarantor. Okay.
Then an application for bankruptcy of a debtor.
Yes.
Here he is a PG, personal guarantor, right?
Yes.
And
because
here below by a creditor individually or jointly with other creditors, or by a debtor again.
Even debtor can initiate, na? So now this process is to be initiated against whom? Debtor only. Who can initiate? Creditors can initiate either singly or jointly, or debtor also can. So like section 10 in case of CIRP, section 10 CRP can be by the corporate debtor also. So here
debtor means corporate debtor here.
No. Here debtor means individual debtor, guarantor. Application for bankruptcy of a debtor. So bankruptcy to individuals ka hi hota hai na? Bankruptcy is with respect to individuals only. So which individuals we are talking about? We discussed that this process can be initiated against a individual debtor who is a personal guarantor to any of the any corporate debtor.
Right.
Okay. So here application can be initiated, application for bankruptcy. Once insolvency resolution process fails, Okay, so after that only it can be initiated either by creditor or by debtor. So this application can be filed under these three situations. One, where adjudicating authority under section 100 subsection 4 passes an order or allows the parties to initiate this bankruptcy process. So section 100, you are aware that under 99 that report is to be submitted by the RP, and based on that report under section 100, adjudicating authority can even order that this insolvency resolution application is rejected. So when adjudicating authority rejected that IRP application, any insolvency resolution process application filed by debtor or creditor, as the same was made for defrauding the creditors, if adjudicating authority is of the view that the application for initiation of insolvency resolution process has been initiated for the purpose of defrauding the creditors, so then the adjudicating authority allows the parties, those who are not committing this fraud. Okay, so then in that case, the application can be filed for initiation of bankruptcy. Second is under section 115. So one is that application for initiation of insolvency resolution process is rejected. Second is the repayment plan which has been prepared under section, that is rejected by adjudicating authority under section 115. Then also adjudicating authority allows the debtor or the creditor to file this application for initiation of bankruptcy. And third is the plan has been approved. Repayment plan has been approved, but it is not fully implemented. So there is a repayment plan which is approved, but debtor makes payment to the creditors, only some of the creditors, not all. The remaining creditor who have been defaulted, against whom default has taken place, and adjudicating authority will allow them that, okay, this debtor has not implemented the plan, repayment plan. Okay, you go and file an application for initiation of bankruptcy process. So these are the three situations. Application for initiation of IRP, insolvency resolution process, is dismissed, not accepted, rejected. Second is resolution plan is rejected by adjudicating authority. Third is plan is approved, but that is not fully implemented. So these are the three situations where applications can be filed. Application under section shall be filed within a period of 3 months of the date of order passed by the adjudicating authority. So this application must be filed within a period of 3 months. Then section 122. Under section 122, application can be filed by the debtor. Okay, so we are talking about the guarantor. Okay, so that guarantor or the debtor, because he becomes a direct debtor here, you are proceeding against the guarantor for recovery. So he is the debtor here. Application for bankruptcy by the debtor. So this can be filed under section 122. I think then procedural things are there, what documents have to be attached. We can skip these things. Then under section 123, creditor has to file an application for initiation of this process. Then what documents are to be attached, that is specified. Effect of application under section 124. So this is interim moratorium. So under insolvency resolution process, the interim moratorium was there under section 96. Here under section 124, similar moratorium is available. Interim moratorium is there, which will be applicable from the date of filing of application till the time the application is admitted. Okay, so effect of section 124 is interim moratorium commences. Bankruptcy trustee, who can be appointed as bankruptcy trustee? So this is specified in regulations. As we are aware that in case of for appointment of resolution professionals also, okay, the regulations are there which specify as to who will be eligible or who will be ineligible to be appointed as resolution professional. Similarly, for appointment of bankruptcy process, eligibility is specified under Regulation 3. Okay. So he should be eligible to be appointed as bankruptcy trustee if he or the insolvency professional entity of which is a partner or director, and all the partners and director, they should be independent. He is not subject to any ongoing disciplinary proceedings. Entity of which is a partner, they are not representing any third party. Then a person shall be considered independent of the guarantor if he is not an associate of the guarantor, is not related party of the CD, has not acted or is not acting as IRP, RP or liquidator in respect of CD. So others are okay that he should not be related to the guarantor or CD, but if he is appointed as the IRP, RP or liquidator in respect of that corporate debtor of which this person is a guarantor, then you can't be appointed. So you can't be appointed as bankruptcy trustee if you are an IRP, RP or liquidator of the CD. And even you can't be appointed as insolvency professional or resolution professional. Okay. Then written consent and all, you can skip. These 3 reports are to be given. As in case of liquidation, we have to submit 3 reports. 3 kinds of reports. One is preliminary report, progress report, and a final report. So preliminary report within 90 days of the bankruptcy commencement date. Progress report at the end of within 15 days of end of every quarter. A final report is to be filed along with the application for discharge order under Section 138. Okay, so as you are aware, the processes are similar, except that some differences are there. So bankruptcy process is also a process where bankruptcy trustee is appointed. He takes charge over the assets of the debtor. He invites claims from the creditors. He constitutes a committee of creditors with the approval of the creditors. Creditors will be voting. Here, the requirement is that resolutions have to be passed with 75%, not 66%. So 75% of the voting share should be there for the approval of a resolution. Then after he verifies the claims, after verification of the claims, he has to, and then simultaneously he has to start the process for selling the assets and realizing the different assets of the debtor. Whatever assets are realized, then he has to distribute them as per the provisions of Section 178. 178 is similar to Section 53. Some small differences there. Otherwise, the rest of the thing is same. So as per Section 178, whatever recovery is there, he will be distributing that amongst the creditor as per their rights. And then there is another provision, which is that as in case of company, we have the provision for filing of application for dissolution. So company has to dissolve. Here, the application has to be filed with the adjudicating authority, and adjudicating authority will be passing an order for discharge of the debtor, and that discharge order discharges him from all his past debt, except there are certain exceptions, including that excluded debt. So excluded debt, against that excluded debt, that order will not apply. Discharge order will not apply. Then there are certain other things that if you have obtained some debt through some fraud or breach of trust, so that debt also will not be discharged. Okay, so there are certain exceptions to all this. So the discharge order, and after that he also submits his report. He prepares a report. Bankruptcy trustee prepares a report about administration of the bankruptcy process as to what has been the recovery, what have been the expenditures, how he has distributed the proceeds. That report is presented to the committee of creditors. That committee adopts the same, And so that is under section 137. And 138 is, so then 138 is discharge. So after adoption of that report of the bankruptcy trustee, so you have to file an application before Honorable Adjudicating Authority for seeking the discharge order to the debtor. But if your sale, you have not completed, your bankruptcy process you have not completed, or administration of the estate you have not completed within a period of 1 year, then in that case also you have to file an application for discharge. And then suppose you have not disposed of the complete assets, but discharge order has to be passed within a period of 1 year. Okay, so that now he has handed over, the debtor has handed over all his assets to the bankruptcy trustee. He has cooperated, he has provided all the records. So it is not that if you are not able to sell the assets for 3 years, you will not issue the discharge order. So law provides that if you have completed the sale before the expiry of 1 year, then in that case, as and when you have completed the process, immediately after that you will be preparing a report, submit that with the committee of creditors who will approve that. And then immediately after that, I think you have to file an application for discharge. But if for a period of 1 year you have not completed, then at the expiry of 1 year, you have to file an application with the adjudicating authority for discharge of that individual, discharge of that debtor, and that order is passed. But passage of that order does not mean that process is completed. Okay, so the bankrupt will be discharged, but he is under an obligation still to cooperate with the bankruptcy trustee. If bankruptcy trustee says that some information is required, he will still be providing the same. Okay, and the bankruptcy trustee will continue to work. He will continue to sell the assets. If some unsold assets are there, realization of debtor is to be made, that he will continue to do the same. And as and when he completes this process, when he is then, and he makes the distribution, then he will be preparing the report, and that report will be presented to the committee of creditor who will approve it. And then the discharge order will be there. The RP will be discharged. No discharge order, rather RP will be discharged from this process after this appeal. This report is approved by the COC. So this is this process. Within this process, we are having provisions which are similar to section 43, section 45, and then this extortionate transaction also. So these provisions are also there under this part 3, where if any preferential transaction is there during the last 2 years, okay, so then the adjudicating authority is having the power to issue direction that the transaction can be cancelled, money can be brought back. Similarly, undervalued transactions are also there. So undervalued transactions are during last 2 years from the date of filing of application. Okay, so here the difference is there. Under CIRP, then from the date of actual initiation of that process, but here admission of that process, but here it is from the date of filing of application for initiation of bankruptcy process. Okay, so then within that 2 years period, if any such transactions are there, and the transactions which are this one preferential transaction, if with unconnected parties, the transactions during last 6 months only can be covered under this preferential thing. Rest of the transaction, but if related parties are there, okay, then in that case the term which is used is associates of the debtor. So then their transactions for the last 2 years, they fall within this category. Similarly, extortionate credit transactions for the last 2 years, those will be re-looked into, and orders can be passed by the adjudicating authority. So very quickly, let's see further. So this is the process. But all the persons, they have to extend corporations, creditors, employees, everyone. And if they don't, you can file an application before Honorable Adjudicating Authority seeking directions to these individuals. Appointment of insolvency professional as bankruptcy trustee, that is under section 125. So whosoever is recommended, whosoever is proposed in the applications of debtor as well as creditor, so he is normally appointed, but adjudicating authority will check that there is no proceedings against that individual, against that bankruptcy trustee who is proposed to be appointed. Okay, no disciplinary proceeding is there against such professional. So then in that case, he will be appointed. Otherwise, you know that if there is any disciplinary proceedings pending against such individual, then IBBA will be recommending some name and he will be appointed as the bankruptcy trustee. So this is appointment of bankruptcy trustee. Bankruptcy order is passed under section 126. Okay, so then after appointment of bankruptcy trustee, within 14 days of receiving the confirmation or nominations. Okay, so first of all, the name of the bankruptcy trustee is referred to the IBBI, and after receipt of report, though in actual practice now you know that the adjudicating authorities, they are having a list or panel of those who can be appointed. Okay, or from there they can see that if any judicial any proceedings are pending, any disciplinary proceedings are pending against them. So bankruptcy order is passed within 14 days of receiving the confirmation or nomination of bankruptcy trustee under section 125. Then validity of bankruptcy order under section 127. So bankruptcy order will remain in force from the date of the order till the time discharge order is passed under section 138. Then order section bankruptcy estate and moratorium. So this is effect of bankruptcy order. On passing of the bankruptcy order, whenever that bankruptcy order is passed, then estate of bankrupt shall vest in the bankruptcy trustee. So as in case of liquidation, when liquidation order is passed, then estate vest in the liquidator. Here estate vest in the bankrupt. Estate of the bankrupt shall be divided amongst its creditor, and then restrictions on initiation of any action or commencement of fresh suit, or so those restrictions are there. The regular moratorium will apply in this case. Now, this particular provision of section 128, bankruptcy order shall not affect the right of any secured creditor to realize or otherwise deal with his security interest in the same manner as would have been done, as he would have been entitled if the bankruptcy order had not been passed, provided that no secured creditor shall be entitled to any interest in respect of his debt after the bankruptcy commencement date if he does not take any action to realize security interest within 30 days. So bankruptcy order is passed, but that does not mean that secured creditor, they are not entitled to sell their assets, sell their security interest or enforce their security interest. So their rights will not be affected. So this process is mainly for unsecured creditors, not for secured creditor, but secured creditor can relinquish their security interest as is there in section 52. And then in that case, they can vote during this entire process. Okay. So then another thing is that if they have decided to sell their assets outside the process, if they don't take any action within a period of 30 days to realize their security, then after that, they will not be entitled to interest on their dues after that period. Statement of financial position has to be given by the debtor to the bankruptcy trustee. Public notice for inviting claims from creditors, section 130. Then registration of claims to be made by the creditors. They have to register their claims with the bankruptcy trustee. I think then I think we can skip all these things. Committee of creditors, then commit regulations, preparation of list of creditors. So after issuance of that notice, whatever claims he receives, he has to process them. And then as per the application which is filed by the debtor, or based on the statement of affairs which is shared by the debtor, then a creditor's list has to be prepared. A bankruptcy trustee has to prepare a list. And see here, it is based on the registration of claims which are made by the creditor. But actual verification takes place subsequent to this. Okay, so creditor list is there. But after that, the claims from the creditors, those have to be verified. And then distribution will be made only after verification has been made. So preparation of list of creditors, then summoning of meeting of creditors within 21 days and all. And then in the committee of creditors first meeting, the creditor committee is to be formed. Voting rights are available to all the creditors. As I told you that there is no differentiation amongst financial creditor or operational creditors, but only those secured creditors, they will not be having any voting right unless they relinquish their security interest, or if suppose there is a secured creditor whose claim is for example 100 crore and his security valuation is only 60 crore, then for the amount of 40 crore he can vote. Okay, and he is required to file an affidavit to that effect, that I will be voting with respect to unsecured part of my debt only, or otherwise he says that I am relinquishing my security interest and I may be allowed to vote for the full amount. Meetings process is similar to our CIRP process or liquidity. It's the CIRP process. Administration and distribution of estate of bankrupt. So how the assets have to be sold, how these assets have to be distributed. So that is as provided under Chapter 5 of Part 3. So bankruptcy trustee shall conduct the administration and distribution of the estate of the bankrupt in accordance with the provisions of Chapter 5. Okay, let's go through the same. And then completion of administration. So as I said that once he has sold the assets, he has distributed the money, then he will be convening a meeting of the committee of creditors in which he will be presenting a report about administration, and that report will be approved by the COC within 7 days of the receipt of report. And then they will determine whether the bankruptcy trustee should be released under Section 148. So if all assets are distributed and sold, so in that case they will recommend that yes, they will say that yes, bankruptcy trustee is released now. Then after that, discharge order under Section 138. So 137 is the report which is to be considered or approved by the creditors committee. And then after that, as I told you, then application has to be made before adjudicating authority by the bankruptcy trustee for a discharge order on the expiry of 1 year from the bankruptcy commencement date, or within 7 days of the approval of committee of creditors of the completion of administration of the estates of the bankrupt under Section 137, where such approval is obtained prior to the period mentioned in Clause A. So if approval of committee of creditors is there before the expiry of 1 year, then immediately after approval of that report, you will be filing an application for seeking this one, discharge of the bankrupt, or on completion of the process, whichever is earlier. Adjudicating authority shall pass a discharge order on an application. So this is very important that with effect from this date, the discharge order is available, and after that he is discharged from all his past. effect of discharge order, we have already discussed. The discharge order under section 138 shall release the bankrupt from all the bankruptcy debt, provided that a discharge shall not affect the function of the bankruptcy trustee. So if suppose he has not completed the sale and distribution, then he will continue to do that. So discharge order does not mean that process is complete. Discharge order simply means that he is discharged. The bankrupt is discharged from this process. It does not release the bankrupt from any debt incurred by means of fraud or breach of trust to which he was a party. Then he is not discharged. This order will not discharge the bankrupt from any excluded debt. Okay, so these are important things. If any debt has been incurred by means of a fraud or breach of trust, then he is not discharged. And then excluded debt also, he is not discharged. Then there are certain disqualification under section 140. Disqualifications are during the period, starting from the date when this process is initiated. Bankruptcy commencement date. Bankruptcy commencement date is when section 126 order is passed. From that day till the time discharge order is passed, there are certain disqualification. A bankrupt or debtor, he can't do certain things which are prescribed here, that he shall be disqualified from being appointed or acting as a trustee or representative in respect of any trust, estate or settlement. So he can't be appointed as a trustee during this period only. Once discharge order is passed, after that he is free, but not during this period. Being appointed or acting as a public servant, he can't be appointed or act. He is already a public servant, then he will cease to be. He can't act as a public servant after that. Being elected to any public office where the appointments to such offices by election. So he can't be appointed as a public office. He can't be appointed as an MLA, MB, etc. But if he is already there, then he can continue. You see the difference in other provisions. Being appointed or acting as trustee, being appointed or acting as a public servant, being elected to any public office. That means he can't be elected to public office, but he can continue to act if he is already appointed. So bankruptcy does not affect his office. He will continue to remain as MP, MLA or anything. Being elected or sitting or voting as a member of any local authority. So if you are any local authority, like you are a member of any local authority, MCD or anything, then you can't be elected, or already elected, you can't sit there or vote as a member. Okay.
So this is for that particular 1 year, no?
Yes, till the time the discharge order is passed.
Maximum 1 year.
Maximum 1 year. Yes. Any disqualification maybe shall cease to have effect if bankruptcy order against him is modified or recalled under section 122. Modification or recall is, suppose by mistake some order is passed, there is some error by which some admission order is passed, or he makes payment of complete dues, then that order can be recalled. So whatever dues are there, he clears them or secures them. So if any discharge order is withdrawn, which is modification or recall, or he is discharged under section 138, till that time only these disqualifications will be applicable. Then restrictions are also there under section 141. So 140 disqualifications, 141 restrictions are there. So these restrictions are that from the bankruptcy commencement date, that is from the date of admission, a bankrupt cannot act as a director of any company, or directly or indirectly take part in or be concerned in the promotion, formation or management of a company. So you can't form a new company, you can't be a director during this period only. Without the previous sanction of the bankruptcy trustee, be prohibited from creating any charge on the estate or taking any further debt. He can't take any charge, he can't take any further debt on the security of this. He has to inform his business partners that he is undergoing a bankruptcy process. So he must inform his business partners that he is undergoing a bankruptcy process. prior to entering into any financial or commercial transaction of such value as may be prescribed, either individually or jointly, inform all the parties involved in such transaction that he is undergoing a bankruptcy process. Then, without the previous sanction of adjudicating authority, be incompetent to maintain any legal action or proceedings in relation to the bankruptcy debt. Then next is important, not be permitted to travel overseas without the permission of the adjudicating authority. So during that 1 year period, he can't travel overseas without the permission of the adjudicating authority. Okay, and this is till the time that discharge order is passed. Modification or recall of bankruptcy order, as I told you, if there is any error or for whatever debts were there, whatever bankruptcy debts were there, he has paid them or he has made them secure, then adjudicating authority will recall that order or modify that order. Standard of conduct under section 143, the bankruptcy trustee must follow the code of conduct. Fee of bankruptcy trustee under section 144. So this is based on, like we are having that regulation 4 in case of liquidation. So similar basis, the based on the sale proceeds in proportion to the value of the estate of bankrupt, he will be provided the fees as per that schedule as provided in the regulations. Replacement of bankruptcy trustee can be made if committee of creditor can change that with a vote of 75%. Then we have resignation. In case of resignation, the new bankruptcy trustee can be appointed by adjudicating authority. Vacation of office is there under section 142, 147. Then adjudicating authority, through the same process, they can appoint some bankruptcy trustee. Release of bankruptcy trustee under section 148. He shall be released from his office with effect from the date on which the adjudicating authority passes an order appointing a new bankruptcy trustee. If some new person is appointed, then whenever new bankruptcy trustee is appointed, he vacates the office or he is released. Then who has completed the administration? If he has completed this process, then he shall be released of his duty with effect from the date on which the committee of creditors approves the report of the bankruptcy trustee under section 137. So not from the date of discharge of the debtor, because debtor is discharged within 1 year. After that also process may continue. So 137 is a report which is on completion of that process. That report is to be prepared and approved by this committee of creditor. So when that that report is approved by the committee of creditor, he discharges from that day. He gets discharged from that day. Then very quickly, let's see section functions and functions of bankruptcy trustee. Investigates the affairs, realize the estate of the bankrupt, distribute the assets. So similar to liquidator. Duties of bankrupt, I think we can skip these. Or duties are acquisition of the property, devolution of any property upon the increase in the income. These are the things where the debtor has to inform. He has to inform the bankruptcy trustee. If he acquires some further asset before his discharge, then he must inform. If there is any devolution of any property upon him, he must inform that I have got some new asset. If there is increase in the income of the bankrupt, he must inform and all that. Rights of bankruptcy trustee. Let's see some approval of creditor for certain acts. So this is section 153. So these things can be done by the bankruptcy trustee only with the prior approval of committee of creditors. Carry on business of the bankrupt as far as may be necessary for winding it up beneficially. If he is willing to continue with the business, then he must take the approval of COC. Bring, institute, or defend any legal action or proceeding relating to the property comprised in the estate, he must take the approval of the committee of creditor. Except as consideration for the sale of any property, a sum of money due at a future time. So normally that money should come immediately or within some period of time. If he is selling it, that some asset, the consideration of which has to come over a period of time, then in that case, he must take the approval. Mortgage or pledge any property for the purpose of raising money for the payment of debts of the bankrupt. So there also he must take the right option or to exercise any right option or other power where he has to make some further money. If suppose he is a shareholder, any right issue is there, he wants to avail that, he must take the approval of the committee. Refer to arbitration or compromise. If suppose he want to refer any dispute to arbitration or compromise, he must take the approval of the COC. Make compromise or other arrangement as may be considered expedient with the creditors. So if he wants to settle some liability, if suppose some creditor is offering less than that, debtor is offering less than the amount which is due, he must take the approval of the committee. Make compromise or other arrangement as he may deem expedient with respect to any claim arising out of or incidental to the bankruptcy estate. He cannot appoint the bankrupt to supervise the management of the estate. So if he is appointing bankrupt for some purpose, he must take the approval of the COC. I think then estate of bankrupt. In the estate of bankrupt, we don't have excluded assets, property held by the bankrupt on trust for any other persons. Also, due to any workman or employee from the provident fund, pension fund, and gratuity fund, such assets is maybe. So we are aware that these assets can't be excluded. Assets are there which can't form part of the estate. Then property held by the bankrupt on trust for any other person, that is also, and all sum due to any workman or employee for PF, etc. So which are there in case of liquidation also. Then undervalued transaction. I have told you already that undervalued transaction under section 140, 164 transaction entered into during the period of 2 years before that, and which have caused bankruptcy process to be triggered. Then we have preferential transaction under section 165, extortionate credit transactions under section 167, if a bankrupt dies, then the process will continue against the if a bankrupt dies, the bankruptcy proceeding shall continue as if he were alive. So it will not affect. He will the bankruptcy trustee will continue to sell the assets. Proof of debt section 171. Bankruptcy trustee shall give notice to each of the creditors to submit proof of debt within 14 days of preparing the list of creditors under section 132. So actually the invitation of claim is after preparation of list of creditors. Okay, so after that he has to give a notice, and then they have to submit proof of debt which has to be verified. So creditors list is prepared first, and after that only proofs of debt have to be invited and which have to be verified by the RP by the bankruptcy trustee. The mutual credit and set off, which is always available. So bankruptcy trustee can't say a debtor that you make payment of your 100% dues, but you are a creditor also. There I will give you proportionately. So right to set off is a statutory right which can't be denied. Distribution of interim dividend. So whatever recovery is made, so he can distribute on interim basis also. And then finally, distribution of property is also possible with the approval of committee of creditors. Okay, so distribution, if you are not able to sell all your assets, then in that case, distribution of property can also be made with the prior approval, with the approval of the COC. Final dividend is whenever you have completed the process, then after that, you will be distributing the final dividend. Section 178 is priority of debt, priority of payment of debt, which is similar to section 53. So first of all, cost and expenses incurred by the bankruptcy trustee. So bankruptcy process for the bankruptcy process. So bankruptcy process cost is to be paid fully. Secondly, workmen's dues for the period of 24 months preceding bankruptcy commencement date and debts owed to secured creditors. Here also, though it is not specifically mentioned, but those secured creditors who have relinquished their security interest. So these two have pari passu, which is there in the case of companies also. Thirdly, wages and unpaid dues owed to employee other than workmen for the period of 12 months preceding the bankruptcy commencement date, which is already there. Here, one thing is not there, which is unsecured financial creditors. Because after payment of dues of employees for the last 12 months, next is, in the case of companies, it is unsecured financial creditor. But here there is no classification as financial or otherwise. So that clause is not here. Next class is statutory dues, central government, state government's dues for the period of 2 years preceding bankruptcy commencement date. And after that, all remaining dues will fall there. So this is section 178. 179 is then mode of sale is similar to liquidation, where he has to sell the assets through a transparent process through the auction. Private equity is also allowed, but in exceptional cases, which are there similar to liquidation. And then 179 section is, which says, I think we can skip all this, offenses and penalties. And 179 is relating to the jurisdiction, that DRT will be having jurisdiction will in respect of all other debtors other than those who are guarantors to the corporate debtors. So I think with this we complete this session. If you have any question, we can discuss the same. I can try to answer the same, or otherwise we can close the process. Close the session. Yeah. Any questions?
Thank you, sir.
Okay, Ji. Thank you.
Sir, I think you have briefly covered the detailed process. In my view, once this bankruptcy process cases start happening, we will require a full day session from you, sir.
Definitely, Anil Ji. Thank you very much.
Because what I could see, there are the steps to be taken by the bankruptcy trustee are huge in a short period of 1 year.
Definitely. Yes, you are right. You are right.
So
thank you very much, sir.
Thank you, Ji. Thank you. Okay. So right. Then we close. Any question?
Thank you, sir. Thank you.
Sir, can you share the slides, please?
Okay. I will do that.
Thank you once again, sir.
Thank you, sir.
Thank you.
Thank you, Nilesh sir. On behalf of ICSI IIP, I would like to place formal vote of thanks from the side of participants as well, and from ICSI IIP, that you catered our request and spare your valuable time for us and deliberate on this specific topic. Thank you so much, sir. Thank you. Thank you all the participants for being there and participating in the session enthusiasm. Thank you.
Thank you.
Thank you, ma'am. Thank you.
Madam, please arrange to share the PPT, madam. From the
Yes, sir. I will mail the PPT of both the sessions over me.
Thank you, madam.
Thank you. Thank you.
एक मिनट, लैपटॉप